Good morning. Good morning, everyone. Welcome to docket number 231102, the application of Connecticut Natural Gas Corporation and the Southern Connecticut Gas Company to amend their rate schedules. We are here this morning and for the next several weeks to conduct evidentiary hearings into this matter. So I think we have a number of administrative matters to get us started this morning. Otherwise, in future mornings, while I will check for administrative matters, I expect to get into cross-examination more quickly. I know we had a procedural conference in this matter, so I won't dwell other than to remind folks that we will take roughly 30-minute lunch breaks, starting hopefully between 12 and 12:30 each day, depending on where we are with the cross-examination of that panel. I do hope to wrap hearings between 5 and 5:30 each night. Otherwise, let's get into other administrative matters for this morning. I want to start by just taking verbal appearances. I know those have been entered into the docket, but just want to make sure I have faces with names. So I'll start with the company.
Good morning. Dan Venora from the firm Keegan Werlin, joined by Brendan Vaughn. We're here on behalf of Connecticut Natural Gas Corporation and the Southern Connecticut Gas Company.
Good morning, gentlemen. Thank you. If other parties and interveners could please approach the mic and just enter the appearance. I see Attorney Wheel, please.
Good morning. Tom Wheel for the Office of Consumer Counsel. I'm joined by Consumer Counsel Claire Coleman, Attorney James Talbert-Slagle, and Attorney Allison McCorney.
Good morning. Thank you. Good morning.
Thank you. Good morning. I'm Shannon Lawn on behalf of Conservation Law Foundation.
Thank you. Good morning, Attorney Wright.
Good morning. John Wright on behalf of the Attorney General.
Good morning, Attorney Inuiji.
Good morning. Obina Inuiji on behalf of DEEP.
Thank you, sir. And Attorney Lopez.
Good morning, Tom Lopez, and I'm also joined with Kim White, Attorney White, and Attorney Brittany Wyman for the Office of Education Outreach and Enforcement. Thank you.
Thank you. Would anyone else like to be recognized this morning? Okay, let's begin with administrative matters. Does the company have any?
We do. I had raised this I had raised this last week with the case coordinator to bring forward today. It relates to the ROE panel. We recognize that Pura will be using a rolling schedule for the hearing agenda, but the companies have determined it's necessary to request that Pura consider setting a specific date for the ROE panel. This is due to a couple of factors. Under the current schedule, if the cross-examination time estimates are accurate, the best we can estimate is that the cost of capital topic would likely occur in the range of April 30th to May 3rd. And we know that the range is subject to change based on the actual hearing time for the panels. However, the company's cost of capital witness, Ms. Bulkley, has a previously scheduled commitment to testify in another jurisdiction on May 1 through May 3, including travel to and from Indiana. And the company's internal witnesses, Mr. Panici and Ms. Ansel, also have a previously scheduled meeting with the credit rating agencies on May 2nd. So what we're hoping to do, and we also understand that the OCC's cost of capital consultant is available only on the dates of April 30th through May 2nd. So given these constraints, we're requesting that the topic, even though Pura has indicated its preference for a rolling agenda, is to schedule a specific date so that cost of capital could be considered on either April 29th or 30th. And the companies would adjust the time they've reserved for cross-examination to enable that topic to be concluded on the designated date.
Okay. Okay, thank you, Attorney Venora. I'm gonna have to take that under advisement so I can look at the agenda for the rest of the week. But just to say this back to you, the request is that the company's cost of capital panel be affirmatively scheduled for the 29th or the 30th. Is that?
That's right. That's right. I mean, we were hoping that this issue would just resolve itself, and it still might. But given the structure, the constraints that we have, that we're trying to just juggle commitments in other jurisdictions, we're trying to provide some specificity around that schedule so we could plan. So that's our request on that issue.
Okay, thank you. I will raise that probably after lunch.
Okay, thank you. I have one other matter, and this relates to the company's motion number 94, which was the motion for clarification of the hearing agenda. We had asked for guidance in that motion because it was, we're trying to understand the process here with respect to Pura requiring the witness panel to appear twice on the same topic for the purpose of separate transcripts. In light of the motion ruling, we are reserving our objection for the record to proceed with duplicate witness panels on each topic. As a practical matter, we believe it will be impossible to duplicate the same information, questions, and answers in two separate sessions for each topic, if that's Pura's intent. It's inevitable that if parties have to repeat questions and answers, there will be variances. And we believe this is prejudicial to the companies, in fact, to all parties. We stated in the motion, and we reiterate here, that there's only one administrative record in the docket, that Pura cannot segregate or bifurcate the record in a contested case to have one part of the transcript apply to one company's application and another part of the transcript to apply to the other company's application. In our motion, we asked for clarification of the process to enable us to properly prepare for hearings because it's not clear to us how Pura intends to implement the requirement of having each witness panel appear twice, once for CNG and once for SCG. With very few exceptions, the testimony and issues presented in the case are identical for each company. Now, I recognize Pura stated in the motion ruling that the typical rules of evidence for administrative proceedings will apply, but this does not provide clarity because the typical rules of evidence per the UAPA provide that all transcripts are part of the record in a contested case. Now, if this statement means that witnesses will be permitted to stipulate to or adopt their testimony from a prior session of the hearing on the same topic, then this may address some of the company's concerns. But Pura's motion ruling leaves this unresolved and states that it will be addressed as the issues arise. So without the clarifications we requested in the motions, the companies are prejudiced in their ability to prepare for today's hearing and therefore object to the process to require each panel to appear twice on the same topic.
Okay, thank you, Attorney Venora. I would say at the outset, I think the issue that you raised just now is why we have procedural conferences. In fact, I think this was a specific item that I myself raised at the procedural conference, half a year ago. With that being said, let me see if I can address this. So understanding that there is complexity that rises with simultaneous rate cases, I think let's start out by saying I don't think adoption is the correct legal term here, but stipulate might be getting closer. So let's start by saying that a witness, if you would like your witness to testify that the answer provided with the previous panel is the same with respect to company B as it was with company A, I think that that is acceptable in lieu of trying to restate the answer, understanding that there are administrative efficiencies in allowing your witnesses to testify. I will say that for sake of the record, during cross-examination, if a question has been asked, that is the appropriate time for the witness to testify that their prior response with respect to the company is the same as it was for the prior company. So just to take a step back and address this more head-on for briefs and later events in the schedule, I think the appropriate thing to do then is for parties, not just the company, but parties and interveners to cite to both testimony of the witnesses So when the witness says that they are in lieu of restating the answer, they are stipulating to the answer provided for the previous company, the parties should cite to the testimony of the witness that the answer is the same as previously provided and to the prior testimony referenced by the witness. I'll pause and take questions in just a moment. Ultimately, I think there are some evidentiary questions that need to be addressed on a more case-to-case basis, which is what the motion ruling was attempting to signify. But let me stop and see if that addresses the company's concerns more fully, using the word stipulate allowing them to stipulate to the answer they provided for the first company.
I guess I'm not appreciating the distinction between the word adopt and the word stipulate. I think we want to be able to have the witnesses do both. I think, again, recognizing this is one record, even though you're going to segregate the transcript, if they've testified for company A on a specific topic, and then the next time through, we would ask them to adopt that prior testimony and stipulate that their answers to that prior testimony would be the same if asked the question again. So that's how we would view that as happening.
Okay, but perhaps we're talking past each other. In my mind, adopting testimony refers to direct testimony, and I think what you're asking to do is to be able to reference to answers provided on cross-examination. So
Right.
I'm asking the company when after a question is posed to the second panel, at that time they can state that their answer is the same as was provided to the cross-examination for the first panel. So since we're talking about cross-examination and not direct testimony, I think the word adopt is not technically correct in my mind.
I think from our perspective, though, when we swear, so the second time through, we would want our panel to adopt their testimony, whether that's the direct testimony, but then also stipulate to all the questions rather than go question by question. Because the questions won't be asked the same second time through. There's no way that will happen. And also, the witnesses will have to rely on memory at that point. We asked to be provided real-time transcripts for all the sessions. We're told that was not available. So we have no way of having the witness rely on their memory for what could be a long cross-examination session and go question by question. I don't think that will work.
Okay.
Because we don't know what parties will do the second time through. They can ask any questions that they want. And that would, so we can't control how they ask their questions or what they, how they do it. So our thought was to have the witness panel at the outset adopt their prior testimony and stipulate that their answers, if asked the same questions, would be the same the second time around. And then cross-examiners could focus on asking, company-specific differences. So if they want to identify, or if there are differences between SCG on this topic or so, and that might come up in the first session too. They might be asked if CNG has a consistent approach on a certain issue to SCG. So I think it's going to be very difficult to put the panels in the spot of going question by question and approaching it that way.
Okay, and in the opening statement, though, let me just take a couple steps back. In the opening statement, there was a concession that there are differences between the two companies. Yes.
There's differences in the outputs and the numbers. I think that the large majority, I want to say 99%, but the very large majority of issues, they're identical to the companies. When you get into things like, let's just take a topic like capital planning, the process is identical. The documentation that the companies provided are identical. There's all that commonality. The same thing in gas operations. The DIMP program is, they're all those things are the same. And so I think when you deal with it on that level, we get to the company specific differences. It's small. It's like on the small, like in terms of like the numbers that are calculated. That conceptually, that's how we see this. So that's why we think the first time through can deal with all of those types of issues. And the second time, there isn't going to be, a need to kind of restate and ask questions again on the entire capital planning process, for example, because it will be the same for both companies.
Okay. Okay. If,
I guess we just want to make sure that, if this is going to be, is this one transcript? Is it two transcripts? Are both transcripts, part of the record for the overall case? That's what we're trying to understand, that element of it.
okay. Let's do this. Does any other party or intervener want to be heard on this question before we issue a ruling? Will?
Yes, Chairman. Tom Wheel for Office of Consumer Counsel. We have no objection to the motion. The only thing I would want to add is my concern is we just don't want to run into situations where if we ask a question of a second panel, that's the same question that we asked of this first panel, that we're going to run into objections that question was already stipulated to. It just, for administrative efficiency purposes on our end, it just makes it burdensome to be able to track, wait, which ones of these questions did they stipulate would be identical the second time. We have no issue at all with, should that situation arise, the company saying, oh, that's one of the ones we stipulated to, and we can just move on. That's my only concern, is that we just don't want to be, I could foresee it happening that we sort of accidentally ask a question that had already been stipulated to in the first panel. So as long as everyone can agree that we're all just trying to do this for the sake of administrative efficiency, we would have no objection.
Okay, and thank you. And does the company then?
I mean, I think I hear Attorney Wheel saying he wants to ask the questions a second time. And that's exactly the issue that we're concerned about, is that we have to have the witnesses answer a second time without the benefit of real-time transcripts and having to rely on, are they answering it exactly the same way they did the first time through? Once it's, once the question's asked and answered, it's going to be in the record. As long as both the CNG and SCG transcripts can be used for this purpose as one record, the information's in the record at that point. And I think it puts the witnesses and the company in a difficult situation if they're expected to answer the same questions twice and not be able to say that the question was asked and answered, or stipulate that the question was asked previously. So I think the questioners can tailor or truncate their questions a second time around to focus on the differences between the two companies and, the specific differences, as opposed to, expecting the witnesses to ask and answer the same questions a second time.
Okay, so I think what we covered at the procedural conference was that there would be two separate transcripts with two separate decisions. And I think what I heard Attorney Wheel say something slightly different, which was a concern that all the parties and interveners in crossing may not recognize that they're re-asking a question that the company has already stipulated to. So I would say my response would be, if that occurred and a question was posed that the company feels that it is already addressed in the first panel, then the company witness's response would be, I believe that was stipulated to. And then the company would, we're talking about CNG or SCG here, the company would have to accept the consequences of stipulating to the same answer over again.
Yeah, we wouldn't look to limit questions. Parties can ask any questions they want to ask. So if I came across it, so it's really just with that in mind, though, we won't limit or try to limit what other parties could ask in their cross-examination. It's really ensuring that we can rely on both transcripts for purposes, or if, assuming there's two separate segments, that we can rely on that for purposes of the overall record.
Yes, and then when we get to briefs, I think what I'm asking is that since the company, so let's say CNG goes first and SCG goes second, when doing SCG's brief, I'd be asking that you cite to both the place in the transcript where SCG has stipulated to the first responses,
Mhm.
as well as the transcript for CNG where the actual response was provided.
Got it. That is very helpful. Thank you.
Okay.
Yes.
Do I need to restate that for anybody? Okay. Okay, so, I think we're getting somewhere. So where are we still talking past each other?
No, I think with that last clarification, that's helpful because it was unclear. Well, I think to the extent that we can rely on both segments of the transcript, the CNG transcript and the SCG transcript for purposes of briefing, and that the witnesses can refer back to their prior answers. I think that addresses our concerns in that regard.
Okay, okay. And if a party asks a question that I feel has already been stipulated to, then if there's any elaboration to provide, they can provide it.
Understood.
Otherwise, stipulate to the, okay.
Yes.
So, and I am looking for you to stipulate to those when the question is asked, I'm looking for the witness to specifically stipulate to the prior answer.
On a question by question basis.
Yes, I think that's where, and is that the last area that we're talking, you want to be able to stipulate to and in the entirety as opposed to on a
Well,
question by question basis?
Yeah, I think it's just I think we can let cross-examiners ask the questions they want to ask, but so I guess I don't want to prejudge how we would answer the question, but you know, because like I say, there could be differences in how the question is asked or so I think we can deal with that issue as we go along.
Okay. In
So,
total
yeah,
agreement, which is I
yeah.
think where we said what we did in the motion ruling, which was that I was a little hesitant to prejudge specific issues as they arise, but I think we have the general scope of the rules of the road here.
I think we do.
Okay, and we'll just have to see how that plays out. Attorney Will, I've left you hanging up there. Do you have anything else to say about this, or do you have another matter?
I just had my own matter, so I was just waiting until
Okay.
I wouldn't sit back down. Thank you.
All right. Any last words on this specific question before I move on?
No, nothing further.
Okay, thank you. Attorney Will, your matter, please.
Thank you, Chairman. We have a couple. I'll start with the easiest one, hopefully, which is just that we notified the authority for the purposes of constructing the agenda of which OCC staff we expected to cross which panels. And I think we just have a couple of additions to that. I think we included Attorney McCorney as to the capital investments panel. If we do end up having cross for the clean energy innovations panel, for which we've just reserved the right for right now, Attorney McCorney would also be conducting some of that cross. And also, secondly, I don't think OCC has introduced the authority or anyone else perhaps to Prabisha Bhandari, who's a new OCC staff member, sitting right next to Consumer Counsel Claire Coleman over there. Ms. Bhandari is a licensed attorney in another jurisdiction. She's working on getting her Connecticut licensure finalized, so she's a legal assistant with us for now. So which is why I'm referring to her as Ms. Bhandari instead of Attorney Bhandari. She may also have crossed for the Clean Energy Innovations panel again if we do exercise that right to cross, and we would also like to add her to the capital investment panel among our staff that may be crossing that panel.
Okay. Thank you and welcome, Ms. Bhandari. Flipping towards the clean energy. Okay, so OCC has currently reserved the right. Is that correct?
Yes, so and we have no adjustment to that as of at this time, but if we do exercise the right to cross, we expect that that would be Attorney McCorney and Ms. Bandari who would be conducting that cross.
Understood. Very good. Thank you. What's next?
Next, I feel like I say this at the beginning of most rate cases, so I apologize, but as the authority knows, our expert witnesses are compensated consultants. Their time is billed to ratepayers. We do our best to limit their billable hours, so we can't unfortunately keep them on standby throughout the entire hearing. We have done our best to make sure that they're available during the times when we expect their panels to appear based on the hearing agenda and cross-examination estimates. Specifically, Dr. Hopkins and Mr. Larkin Connolly, who filed testimonies and rebuttal for the capital investment panels. They will be available to testify at the beginning of next week, and based on our calculation, we expect that they should be called on the April 29th. I'm only raising that panel specifically because in the interim, since we last updated the authority as to availability, Dr. Hopkins ran into an issue that will make him unavailable to appear in this first week. So I'm just notifying the authority of that. The other issue with that I wanted to raise for Dr. Hopkins is that he's listed also to return to Connecticut to testify on our depreciation panel with Mr. Dunkel. And we assume that's because the company's depreciation rebuttal testimony addressed some of Dr. Hopkins' initial testimony, so sort of maybe brought the issue of depreciation into his testimony. I did briefly speak to Attorney Venora about this and asked whether the company would object to just asking all of its cross of Dr. Hopkins when he first appears as to the capital investment panel, rather than have him return for the depreciation panel. But recognizing, of course, that authority staff and others may also have reserved time for the depreciation panel. So I'm just asking if Dr. Hopkins could be excused from having to return to the depreciation panel and can just appear during the capital investment panel.
Chair Gillette, could I suggest, could Attorney Wheel and I discuss that on a break? And because I just want to talk about that. I don't think I understood it the same way.
Okay.
Okay.
We had a really brief exchange, so we may have not fully understood each other.
Okay. All right. So let's take that under advisement. So let me understand the entirety of the request, which is that Dr. Hopkins, you're inquiring as to whether he could only come once for capital investments as opposed to also the depreciation panel. Does OCC have other witnesses on depreciation? You do.
Yes, Mr. Dunkel. So Mr. Dunkel's testimony is specific to the depreciation expense, but Mr. Dunkel's testified for us in other cases, obviously, and his testimony is directly responsive to the company's depreciation testimony. Dr. Hopkins' testimony is about primarily focused on the future of gas and is responsive to the company's capital investment testimony. He does mention depreciation sort of as an element of his testimony, but he doesn't address the company's specific depreciation study or anything like that. So I think Dr. Hopkins isn't a depreciation expert and wouldn't be able to respond really to technical questions about depreciation curves, useful lives, the sorts of things that come up during depreciation. So that's the nature of our request.
Okay, thank you. So we'll look to close the loop on that after the lunch break. But then the first part of your request was that you were hoping the capital investment panel would go on the 29th. Is that?
Yes, well, our capital investment panel witnesses, Dr. Hopkins especially, Dr. Hopkins isn't available this week, but can be available at any time next week. So the agenda has him and Mr. Larkin Connolly, who I think actually could be available this week, but I imagine it would make the most sense for them to testify together. So not specifically the 29th, I'm just raising the
Anytime next week?
Yes.
Okay. All right. Thank you. Anything else?
Two more. Next, just wanted to note that tonight's the first night of Passover. We have some staff who may need to leave early to observe, and we don't need to make any adjustment to our appearance in this hearing for that. We just wanted to note that if company witnesses or anyone else needs us to make any kind of accommodation for that, we would have no objection to taking witnesses out of order or anything to that effect. It's not asking a question, just letting everyone know that if that becomes an issue, that's OCC's position on that.
Thank you. Can I interrupt and ask what time what time, if someone needs an accommodation, what time that is? Is it,
I believe Passover begins at sunset. So I believe the accommodation would just be able to get to religious services in time for that. I'm not sure when the sun sets this week.
okay, thank you.
But again, we don't need to limit any of our staff's participation in terms of cross-examining or offering witnesses during the hearing. We can make sure that we don't need to make any adjustments to the schedule for that purpose. We're just saying if anyone else has an issue with that, we'd have no objection to making adjustments.
Okay, thank you. It looks like sunset is at 7:40 PM. So I will look to parties and interveners to ask if you need an accommodation if we are bumping up against that.
Thank you. And my last one, it's sort of a I wasn't sure whether to raise this during a witness panel or now, but I obviously lean towards now. We received some objections to discovery responses, specifically OCC 685, OCC 687, OCC 689, and OCC 691. And the nature to the commonality between all those objections is that the company raised that we are requesting documents that are available in the public record. And we don't disagree that the documents we requested are publicly available, but we're just, I guess, looking for clarification from company's counsel that we can reference the documents that are publicly available that weren't provided in response to those interrogatories without an objection to those documents not being in the record.
Thank you. And Attorney Venor, if you need a moment to pull up those interrogatories.
Yeah, I hadn't heard about this prior to, so I didn't have them. I don't have them right here. I'm pulling them up.
And Attorney Wheel, just make sure I got those down right. You said 685, 687, 689, 691.
Yes.
Those four? Okay. Thank
So,
you.
yeah, so for these questions, and, in this series, we noted that OCC wanted information on rate cases going back about 20 years in terms of authorized rate base, authorized rates of return, all information that's included in the rate case decisions. We provided the ones that were easily obtainable, like from the last rate case forward for each company, and referred them to the other materials. If they have cross-examination and want to ask questions about information from prior rate cases, they can pose those questions. So we weren't saying the information, we viewed the information as equally available to OCC if they wanted to go back, that number of years.
And thanks, Attorney Venor. Maybe to help, the second set of questions were the ones asking for the quarterly ROE filings, and it was a similar, I think the basis of the objection was similar, that those filings are in the Pura dockets. But my question was, I guess, more a question for the authority, because the company didn't provide all of the rate case decisions or quarterly ROE filings that we requested. Do those documents need to be admitted in the record in order for us to reference them in the brief, or is it sufficient? Are the company's responses here referencing where they are publicly available sufficient for us to be able to reference them as in the record?
Okay, I'm still struggling to pull up the company's objections to them, but based on the information just now, I'll provide an initial response, which is the authority's position is if there is a Pura decision that has been voted on and adopted by a majority of commissioners, that can be cited whether or not it's in the record, because it's stands for its own validity. The quarterly ROE filings, which are not PURA decisions, but rather filings made by the company into a PURA docket. Let me just confirm with the company's counsel, in your objection, which I apologize, I can't seem to pull up, if it instructs where that information is, I would accept that as something that could be pointed to in a brief, or you could ask a question about it in the record. So that would be my tentative ruling. We'll see if the company wants to respond to that.
Yeah, so that's fine. I mean, we provided in the answer, they wanted the quarterly ROE filings going back 20 years. So we provided the ones that were since from the last rate case forward, and then provided a link to where they are housed on the authority's website. So
Okay.
that was how we approached that question.
Okay, then I will confirm that that the OCC or others could ask questions based on those filings and or cite to them in their brief. I think that resolves that issue. Anything further, Attorney Wheel?
No, thank you very much.
Okay, thank you. Attorney Venora.
I just have one last question, at least for this this initial week of hearings. We have some very large witness panels. 30 minutes is going to be very difficult if we're limited to 30 minutes for lunch. If the authority would consider extending the lunch period to 45 minutes so we can get people across the parking lot fed and back in time, that would be appreciated. Especially, as I said, we have some with revenue requirement in particular, we have a lot of people here to be prepared for the hearing. So if the authority would consider that, we would appreciate it.
Okay, I will consider it. I'm concerned, I need to go back and that's why I took under advisement the company's ROE request and the OCC's capital investment panel request, which sounds like there's more flexibility around. I'm not entirely sure that I can do both. So let's, I will do my best based on where we are each day. See if I can
Okay.
pull this all together.
All right. Thank you.
Thank you. Any other party or intervener? Attorney Lon. What panel is that, Attorney Lon? Thank you.
The company has no objection to that.
Thank you. Then I will add you, Attorney Lon, to the reserve. You're gonna affirmatively have cross, or do you want me to list you as reserved there, right? Okay, thank you. I will add you to the gas operation panels. Anything further? Okay, thank you. Okay, anybody else? All right. Then let me revisit after the lunch break, the panel availability issues that I'll take under advisement. And I think we can move into our first panel. Attorney Venora, picking up from our conversation earlier, assuming that the witnesses are going to be the same for both companies, my preference would be to swear them in once and then to remind them that they're under oath for the second panel. Any objections?
No, no objection.
Okay, very good. Then I think we're ready for our first panel, which is case overview and regulatory policy. So if you could introduce your witnesses, please, and then I will administer the oath.
Good morning. Mr. Langland and Mr. Canavan, would each of you please state your full name and positions for the record?
Sure. Daniel Canavan, Vice President of Regulatory Affairs. Good morning.
Good morning, Al Langland, Vice President for Gas Engineering and Operations for Avangrid.
Welcome, gentlemen. If you could please raise your right hand. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
I do.
Thank you. Attorney Vaughn.
Mr. Canavan and Mr. Langland, as part of your preparation for this docket, did each of you co-sponsor pre-filed direct testimony in this proceeding, which were marked as exhibits CNG-ACL/DRC-1 and SCG-ACL/DRC-1?
I did.
Yes.
Mr. Langland, did you also co-sponsor pre-filed direct and rebuttal testimony as part of the gas operations, capital investment, and clean energy panels, which were marked as exhibits CNG-GOP 1 through 3, SCG-GOP 1 through 3, CNG-CIP 1 through 7, SCG-CIP 1 through 8, CNG-CEIP 1 through 8, SCG-CEIP 1 through 8, CNG/SCG GOP Rebuttal 1, CNG/SCG CIP Rebuttal 1, CNG-CIP Rebuttal 2 and 3, and SCG-CIP Rebuttal 3.
I did.
Did each of you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
Yes.
Do either of you have any updates or corrections to your pre-filed testimonies or interrogatory responses not previously identified for the record in an interrogatory response?
I do not.
I do not either.
And do you adopt your pre-filed testimonies and interrogatory responses as part of your sworn testimony in this proceeding?
I do.
I do.
The panel is available for cross-examination.
Thank you very much. And I apologize, I neglected to call the OCC up. I think you're up first for cross-examination unless, is there any direct testimony from this panel? Oh. Any additional?
There's not.
Okay.
There's not.
Thank you. Then we'll let the OCC get situated and then yeah, just watch your head on that TV. I don't want you to lean back and, yeah. Good. Okay. Good morning, Consumer Counsel, Attorney Wheel.
Good morning. Good morning, Tom
Hey.
Wheel from the Office of Consumer Counsel. I'm going to start with question about your initial testimony on page 4. The portion discussing the joint petition from the Attorney General, OCC, EOE, and CIEC. It's just maybe a correction that may have already been caught elsewhere in discovery, but I didn't notice. That testimony says that the joint petition requested a rate hearing of SCG relating to its earnings report in the fourth quarter of 2022.
Good morning, Attorney Wheel, Dan Canavan, and good morning, Consumer Counsel Coleman, as well as everybody else. Good to see everybody. Thanks for being here. I don't know if there was a question posed, but happy to address anything you raised.
Oh, sure. I just want to make sure we're looking at the same thing. So it's line 16 of page 4 that I'm referencing. Wasn't it CNG that over-earned in the fourth quarter of 2022 and not SCG?
Well, certainly on line 16, it does reference SCG. We can certainly revisit that and probably correct that through a reading if it requires the overearning.
I wouldn't need to read it. I was just looking for confirmation that that's an error in the testimony.
Yeah, off the top of my head, I'm not sure I can say yes or no, it was an error, but happy to look into it.
Okay, thanks. And that quarterly earnings report is actually in the record in response to OCC 691, attachment 1.
Would you like me to turn to that?
Yeah, I have some questions about that. On page 106, 103 is where that quarterly earnings report starts.
Can you just restate the interrogatory number one more time?
Yep, OCC 691, attachment 1.
In page,
The quarterly report starts on page 103, but my first question is about page 106.
okay.
Okay. So that 106, page 106 there shows that CNG had a pre-earning adjusted return on common equity of 11.07%.
That's what it says, yes.
Okay. And do you know what the authorized rate of return on equity for CNG was for that period?
Yes. For CNG, it was 9.3.
Okay, thank you. And just for the benefit of anyone who might not be familiar with the term over earnings, just had some questions about that. So would you agree that the return on common equity is roughly an analog for the company's profit?
Not necessarily.
Okay, in what way?
Well, certainly, I think you're going to hear some great witnesses to talk about how these ROE calculations are made. We're going to have some witnesses later on in this proceeding. Our ROEs are set or should be set. Certainly, these companies did over-earn at a time, which led to this rate case, given the AG's petition in May. And certainly, some back and forth in motion in the spring of 2023 led us to agree that companies would file these rate cases in November of 2023, and that's why we're here. So certainly, did these companies over-earn during a period of time? I think the record is clear on that. And I think you're going to hear some great reasons on why that was. You're going to hear also going forward why when we project out and through the rate plan, why there's still a rate deficiency that these companies need to build into rates, whether that's the plant that has been put in service, but yet not yet recovered through rates. And certainly when you forecast plant through the rate year, that would also project a rate deficiency over current rates. Companies' current earnings are well below their allowed. So while there was a spike at the end of 2022, as we suspected, those earnings sharing, so over earnings were transitory and are now well below allowed, and we expect will continue to move downward.
Okay, thank you. I'm just trying to get to narrow down on what over earning means. So my question originally was asking what the return on equity actually is. And I guess I'll ask another way. Is it true that us built into the rates that PURA allows in a rate adjustment proceeding like this one, that a component of that rates is intended to compensate the company for the return on equity?
I would agree with that.
Okay, so that level of compensation is set at a percentage rate rather than a dollar amount. Is that right?
Generally speaking, yes.
Okay. So when we say that the authorized rate of return in 2022 was 9.3%, that means that the company was authorized to earn an amount equivalent to 9.3% of the value of its equity and rate base. Is that your understanding?
Correct. I would say it's slightly different. I would say that the company is allowed the opportunity to earn the 9.3 on its rate base. There are certain circumstances why perhaps it wouldn't earn that much, and there are certain circumstances why it would earn over that amount. And we have an earnings sharing mechanism for that very reason, that when those allowed earnings go over the actual earnings go over the allowed, that we share under the current scheme 50-50 with customers. So there is a mechanism that acknowledges that over earnings can occur. And when it does, the mechanism kicks in and provides 50-50 sharing with customers.
Thanks. So just to get it back a little bit more basic about the mechanics here. So the company gets its revenue from rates in a given year, and just like any other company, it uses that revenue to pay all of its operational costs, correct?
Generally correct, yes.
Okay. And then other than the cost of equity, because that's sort of what I'm getting to last. Whatever is left over after all of the operational costs are covered and the cost of debt, that's what we're talking about when we're talking about what the earnings are in a given period.
Generally,
Okay, when you say generally, am I missing
yeah, I
something?
just don't want to get in front of the very exceptional witnesses that are coming up in the balance of this proceeding on these topics.
Sure.
Which can provide much more detail than I will today, quite frankly.
Sure. Understood. So in the fourth quarter of 2022, when we say that the company earned a return on equity, the pre-sharing adjusted return of 11.07%, what that means is that the amount that was left over after accounting for all the costs was an amount of money equivalent to 11.07% of the value of equity in the company's rate base.
Again, I don't want to get in front of the witnesses who deal with these issues on a day-to-day basis, but I think that's generally correct.
Okay. And I didn't notice anything in your testimony that referenced this. In fact, the only reference I saw to the over-earning was the sentence that I started my cross with. But did the company determine why it was that it was over-earning in 2022?
Yeah, so there's no one single issue that you'll see cause the over-earnings in that one quarter in 2022. You probably see a number of small items that combined created a situation where there was a transitory earning effect for 2022 that triggered the earnings sharing mechanism. Again, I think the witnesses coming up would be much better suited to give you more detail on the specifics.
Okay. Thank you. And your testimony on page 6 references how CNG's last allowed multi-year rate plan set revenues designed to last through the end of 2021. Is that correct?
Correct.
So the rates that are in effect today, is that same level of revenue that was established in that rate plan?
Yeah, that's right. Correct.
Okay. Are you aware of the level of operating income that was set in that 2021 decision?
I'm not off the top of my head now.
Okay. So are you able to compare the operating income reported on that fourth quarter 2022 earnings report against the operating income that was set in rates for the
I would not be able to, but again, the revenue requirement panel will be well positioned to do that for you.
Okay. And looking at page 8 of your testimony, 2022 is the test year for this case, right?
That is correct.
Okay. So in the test year, then the company over-earned?
Yeah, the over-earnings were in the fall of 2022, and that is the test year.
Okay. Well, it's specifically referencing back to that earnings report. That over-earning period is for the 12 months ending December 31st, 2022, correct?
That's right.
Okay. And that's the same 12 months as the test year, correct?
That's still correct.
Okay. Are you aware of the level of earnings reported for year-end 2023 for CNG?
I am not.
Okay. That's in response to OCC 691, attachment 1, again on page 125.
Attorney Wheel, is Mr. Canavan or Mr. Langland a witness on that response?
I'm not sure. Maybe you can tell me, Attorney Venora. It's the response. It's whoever the company chose to answer the interrogatory.
Right. I don't think it is.
Okay. So you're not aware of the level of earnings in year-end 2023?
I mean, I'm generally aware of these documents. I don't produce them. I don't create them. I think there are witnesses in this docket who have sponsored them that are more familiar with these documents.
Okay. Are you generally aware of, I mean, you were just testifying about how the company has been under-earning in recent years. Are you generally aware of the financial performance of the company in 2023?
Yeah, I think our recent filings for CNG and SCG reveal earnings below their allowed.
Okay, but you're not aware of what the year-end 2023 filings reveal?
I think those are the ones I'm referring to.
Okay. So, but you can't speak to what that level of earnings was?
no, I think, if you're going to get to the details here, I think there's a better panel that's suited to provide those answers.
Yeah, and I have confirmed that, so the OCC 691 is our primary witnesses on the revenue requirement panel.
Okay. I mean, but your testimony addresses the necessity for the company to come in for a rate case because of the revenue deficiency, correct?
Well, it references it. I think that revenue deficiency also further explained in the revenue requirement panel. There's no question.
Okay, so are you not exactly sure what the revenue deficiency is then?
Oh, yeah, no, the revenue deficiency is stated in my testimony. My testimony is not designed to support the revenue requirement or the revenue requirement model or the standard filing requirements that support that. But certainly we've identified the revenue deficiency for both companies throughout the case.
Okay, what is your testimony designed to support?
Yeah, it's really just provide an overview of the case of what people would see when they review the balance of the testimony. I think there's 13 panels that have provided testimony in this case. There's 2,500 interrogatories. Certainly, I've not drafted all that testimony or provided all those discovery requests, but my testimony here today was to provide an overview of what you may see when you get into the case.
Okay. And your testimony specifies that CNG is seeking an increase of $19.8 million. Is that correct?
That's correct. That's further described in the revenue requirement model, SFRs, testimony, and exhibits.
Okay. Just a couple more questions. Turning back to the questions I was asking a minute ago about the distinction between SCG and CNG with respect to the petition. Didn't that petition only call for a rate hearing for CNG?
I'm not sure, actually. I think the back and forth of the motions in the spring of 2022, it was determined, and then ultimately Pura agreed that we would file both cases for review in November of 2023.
Okay, that was going to be my question was why your understanding of why both companies filed.
Yeah, well, both cases have been, I've not read the Attorney General's petition in some time, but both companies were out of rate cases for some time. Last rate case for CNG was 2018 and SCG was 2017. We thought it would be appropriate for both companies to be reviewed. Both companies in our projections do have revenue deficiencies for the items I've said earlier. Both of these companies were ripe for review, and we thought it best to provide both companies for PR in a rate case.
Okay. That was my last question. I'll turn it over to Consumer Counsel Coleman.
Good morning. Good morning, Chair. Good morning, Commissioner Karen, Mr. Canavan, and Mr. Langland. I just have a few kind of broader, high-level strategic questions that hopefully you're well positioned to answer, considering your positions with the company. In your testimony on page 19, you acknowledge that in May of 2022, the Connecticut General Assembly passed Public Act number 22-5, an act concerning climate change mitigation, which established ambitious statutory renewable energy goals, and for the state of Connecticut, amends section 22A-200A to require the state to reduce the level of emissions from greenhouse gases to at least 45% below 2001 levels by 2030 and 80% below 2001 levels by 2050. In light of that acknowledgement, do you agree that in order to meet these emission reduction mandates, decarbonization of our building sector will be required or is required?
I think in general, yes.
So just broadly speaking, thinking about CNG's rate case application, which seeks substantial increases to its capital budget, how have you considered protecting customers from the high risk of stranded costs for investments that may, at some point in the future, no longer be considered used and useful to the benefit of customers?
Well, certainly I'll start and Mr. Langland can jump in, but certainly we've presented a case that includes the capital investments that have been made during the interim period and we expect we make during the forecasted rate years to provide safe and reliable service to customers under currently existing rules and regulations. We appreciate that there may be a time when the gas business looks different, but collectively here in Connecticut, we've not had a discussion of what that would look like going forward. So we thought for a one-year case, it made sense to provide The case that we presented, which include additional DIMP spend, because we think DIMP is important. We think that's a good policy, has safety and environmental components to it. And it also includes additional work to maintain safe and reliable system, which our customers expect. We also continue to add new customers to our customer base on a daily basis, even after system expansion has come to a close. So where we are today in Connecticut, where the system is today, we thought we'd put forth a reasonable case from a capital standpoint that'll get us through November 2025. And if there are, going forward, if there are additional concerns that the company needs to take into account during its planning phase, we certainly will. But right now that, unlike in other states, we are not quite there in Connecticut.
Thank you. So in terms of the focus on safety and reliability, are the, and I know we'll get into this in more detail with the capital panel, but generally speaking, are the capital investments included in the application solely related to safety and reliability investments needed in the company's view?
Again, I think the details would be best described by the panels, but I think for the most part, I mean, we certainly look at this case as getting on track with our 20-year cast iron bare steel replacement program as being the most impactful to reducing fugitive emissions, improving safety and reliability for our customers.
Thank you, Mr. Langland. With respect to that proposal, I know that's included in your clean energy investment panel and testimony, but your testimony also briefly mentions research and development initiatives and capabilities necessary to inform natural gas decarbonization. Given Mr. Canavan's testimony that you're really just focused on the next year, combined with I think the testimony you just made about kind of considering these broader longer term policy goals and mandates, what in particular within that research and development initiative is incorporated into this rate application?
Well, I think we have, several. We have the clean energy pilots that we're looking at. We're looking at a clean energy supply team. We can put a focus on geothermal efforts, various other efforts around NPA solutions, potentially looking at that whole decarbonization effort. And I think, as you talk about the business moving forward, now is the time more so than ever that the company should be investing in these kind of R&D's activities that they haven't participated in the past.
Thank you. And you mentioned a focus on geothermal. My recollection is that your application does not include any proposals for any geothermal pilots. Is that correct?
That's correct.
And why is that given?
Again, it's a one-year case. We have some, within the Island Grid families, we have some geothermal pilots taking place in New York. There's one in Framingham for Eversource, and we're looking to, learn from others before we dive into that space.
Yeah, I believe I'm most familiar with the Framingham one in Massachusetts, which I believe is anticipated to both reduce customer utility bills and reduce carbon emissions. Is that your understanding?
It is.
And has the company made an affirmative decision that it's not in the best interest of Connecticut's gas customers to pursue a geothermal pilot?
We have not at this point. I think others will decide how fast or slow or if this energy transition, occurs. My focus is on the safe and reliable delivery of the gas system that we have today.
Just have one more sort of big picture planning question that transcends, that's appropriate for you both as Avangrid and UIL executives. One of the things we think about is the impacts of usage of natural gas for heating versus usage for the regional power sector, of course, and being a company that serves both gas customers for that utilize gas for heating as well as electricity customers under UI have the similar challenges and concerns around electricity reliability given our natural gas constraints. Where does sort of those considerations intersect with company planning in terms of thinking about gas expansion or reduction or for the heating sector versus preserving gas capacity for the power sector for electricity customers.
Well, I'll start off and Mr. Lane can jump in, but as a supplier of last resort, we have capacity for all our customers, commercial and industrial, residential. And as long as those customers exist in our system, I suspect the company will maintain that capacity as we move forward. I mean, we still are adding customers on a daily basis. Our customer base is getting larger, not smaller. And we are working to accommodate those customers in their needs, whether it's home cooking or home heating or industrial, for whatever the industrial uses that they have in mind. Anything to add?
No, I think the electricity market is certainly constrained for natural gas, but we have an obligation to serve our customers here in Connecticut, a firm obligation to do that, and that's our intention.
I believe that's all I have. Do you have anything else? That's it for the OCC.
Thank you. You may want to sit there and see if anybody else has crossed before we turn to the next panel. Did Para staff have cross for this panel? I didn't hear an appearance from an attorney Gagne or attorney Camillo this morning. Okay, attorney Anoiji. Attorney Wright. Thank you. Attorney Lopez. Okay, thank you. Any questions? Questions? Thank you. Redirect?
We have no redirect.
Thank you. Okay, so we'll turn to the same panel focused on the Southern Connecticut Gas Company. Remind the witnesses they remain under oath. Any additional materials to adopt for?
Just a few preliminary questions, if we could. Mr. Langland and Mr. Canavan, do you recall answering a series of questions from Mr. Vaughn at the start of your testimony in the CNG portion of this hearing?
Yes.
Yes.
And do you also recall answering questions on cross-examination from attorneys Coleman and Wheel during that portion of the hearing?
Yes.
Yes.
And now, in appearing now for SCG and for purposes of administrative efficiency, do you adopt your testimony from the CNG transcript and stipulate that if asked those same questions again, your answers would be the same?
Yes.
Yes.
That's all we have. The panel is available for additional cross-examination.
Okay. An attorney Venora, do we want to add to that question that you asked him in the beginning, just the 2 words if asked? So just apologies for the interlude here. I just want to make sure we get this right as we do this the first time. So you asked the question, if you are asked the same questions, would your,
I believe that's what I said.
that's what you said.
I think I did. I could have her read it, but I agree with you. That is how, so if asked those same questions again, your answers would be the same. And then the answer.
That was it. Okay. Apologies. I didn't
No, no
listen
worries.
quite
Thank
close
you.
enough. Okay. Very good. Then, Attorney Wheel, I think the floor is back to you. Apologies. I just want to make sure I get this right since this is the first time that we're and try this out. So Attorney Wheel.
Sure, thank you. Good morning again, Tom Wheel for the Office of Consumer Counsel. So given the company's stipulation as to the questions just asked of the CNG panel, I'll try not to repeat any questions that were already addressed, which I think maybe just leaves 1 or 2 questions. The first, when I asked them during the CNG panel about reference on page 5 of the testimony to the joint petition of the Attorney General, OCC, EOE, and CIEC, I noted that there's a reference there to a SCG earnings report for the fourth quarter of 2022. The testimony the first time, as I recall it, was that Mr. Canavan, you couldn't speak immediately to whether that was a CNG or SCG report. I have a slightly different question, which is just to confirm, is it your understanding that SCG over-earned in the fourth quarter of 2022?
I believe that's the case, but certainly the records filed in this case would support that conclusion if accurate.
Okay. And actually my next questions were going to be similar to the questions I asked regarding the fourth quarter 2022 earnings report, essentially asking about the content of that report, but acknowledging that you didn't sponsor that interrogatory response. Can you speak to the recorded financial report of SCG for the fourth quarter of 2022?
I mean, again, the documents stand for themselves, but
Attorney Wheel, if it helps, we do have the witnesses here that can speak to all that. I mean, they will be on the revenue requirement panel, but we could bring them up now if you'd like.
No, that's fine. I plan to ask all these questions at the revenue requirement panel. I just for clarification, just trying to highlight the questions that may be different responses than I asked before, because these pertain to SCG. And I think the remainder of my questions that were specific to CNG during the CNG panel, I believe generally your responses, Mr. Canavan, were that those might be better addressed by the revenue requirements panel. Is that accurate?
certainly that was my response to a number of your questions. Yes.
Okay. So would you have the same response if I asked you questions about the specifics, for example, of the what's built into the rate model applicable in 2021 for SCG?
Yeah, I think those questions would be better fielded by the experts on the revenue requirement panel.
Okay. So with that, I have no further questions, and I believe Consumer Counsel Coleman's questions were applicable to both companies, so we're satisfied with the stipulation as to the responses from CNG.
Okay. Authority staff have questions for this panel? Attorney Gagne or Attorney Canio? Attorney Anaouiji? Attorney Wright? Attorney Lopez? Okay, thank you. Questions? Any redirect?
No, we have no redirect. Thank you.
All right. Thank you. All right, the next panel is our revenue requirements panel. So I'll ask that the authority staff approach the cross-examination table and that the CNG witnesses approach the bench. I'm sorry, approach the witness table. Okay. When the company is situated, if you want to introduce your witness panel, please.
Thank you. Mr. Adams, could you please introduce yourself and state your name and position for the record?
name is Michael Adams. I'm the Senior Vice President, Central Energy Advisors.
Thank you. Ms. Hurwitz, Ms. Wakefield, Ms. Van Luling, and Mr. Dane. As the primary witnesses on this panel, would each of you please state your full names and positions for the record?
Laura Wakefield, Manager, Revenue Requirements.
Andrea Van Leeuwen, Networks Controller.
Jacob Hurwitz, Senior Director, Revenue Requirements. And Daniel Dane, President, Concentric Energy Advisors.
Yes.
Okay, and you have a number of other witnesses. Did you intend to introduce them only if asked, or how do you want to proceed?
That was our thought for efficiency, Chair Gillette. So the witnesses, our primary witnesses on the revenue requirement panel will be prepared to adopt for purposes of admission into the record all the discovery responses that others have answered. And then to the extent they need support from any of those additional witnesses, every single one of them are here and can come up as needed to provide that. But we thought that would be considering we have a large number of people, that may be a good way to move through this.
Okay.
Okay.
All right. Well, then if I can ask those witnesses who are just introduced to raise your right hand, please. I'll administer the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
Thank you. Any found?
Thank you. Ms. Hurwitz, Mr. Hurwitz, Ms. Wakefield, Ms. Van Luling, and Mr. Dane. As part of your preparation for this docket, did each of you provide pre-filed direct and rebuttal testimony and exhibits in this proceeding, which were marked as Exhibit CNG/SCG RRP 1 through 13 and CNG/SCG RRP rebuttal 1 through 5?
Yes.
Yes. Did each of you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
Yes.
And do you have any updates or corrections to your pre-filed testimonies or interrogatory responses not previously identified for the record in an interrogatory response?
No.
Yes.
Mr. Hurwitz, could you please explain?
While preparing for hearing today, we determined that our response to EOE 544, which sought a list of adjustments to the revenue requirement identified through the course of discovery, inadvertently omitted a correction identified in response to EOE 360 with respect to the treatment of residential customer security deposits. We did not intend to omit that correction, rather it was inadvertently left off of our response to EOE 544, and we will reflect the stated correction in EOE 360 in our next revenue requirement update in this proceeding. And I have two corrections to the rebuttal testimony that we filed. That was Exhibit CNG SCG RRP rebuttal -1 on page 27 of 45. And this correction is intended to match the numbers in the testimony with the numbers in the supporting exhibits. So specifically, the sentence on lines 2 to 3, which currently read, reflecting the correct inflation rate in the analysis results in average inflation-adjusted capital expenditures of 68.7 million for CNG and 90.8 million for SCG. Those two numbers should be 68.3 million for CNG and 90.2 million for SCG. And those numbers that I just read are reflected in the exhibits. And similarly, on lines 10 to 12 of that same page 27, there is a sentence that reads, applying an inflation adjustment from 2023 to the rate year results in a rate year plant additions amount of 70.9 million for CNG and 93.7 million for SCG. Those two numbers should be 70.5 million for CNG and 93.1 million for SCG.
Thank you. And subject to those clarifications, do you adopt your pre-filed testimonies and interrogatory responses as part of your sworn testimony in this proceeding?
Yes.
Yes.
And lastly, for purposes of admission into the record, have you reviewed and do you adopt the interrogatory responses sponsored by the other witnesses identified in the revised hearing agenda for the revenue requirements panel?
Yes.
Yes.
Thank you. Mr. Adams, as part of your preparation for this docket, did you provide pre-filed direct and rebuttal testimony and exhibits which were marked as exhibits CNG MJA 1 through 3, SCG MJA 1 through 3, CNG MJA rebuttal 1, and SCG MJA rebuttal 1?
I did.
And did you also sponsor responses to interrogatories submitted in this proceeding?
I did.
Do you have any updates or corrections to your pre-filed testimonies or interrogatory responses not previously identified for the record? And do you adopt your pre-filed testimonies and interrogatory responses as part of your sworn testimony in this proceeding?
I do.
Thank you. The panel is available for cross-examination.
Okay. Very good. Thank you. I think now is probably an appropriate time for me to give the instructions about late file exhibit 1 before we get into our cross-examination that may yield additional late file exhibits. So for each rate case, as we have with previous rate cases, late file exhibit 1 is the request for the company to provide a list of capital projects identified in the rate application as may have been amended with authority approval that are in service as of the close of the record, inclusive of any adjustments for errors or other information uncovered during the hearings. So that's meant to capture Mr. Hurwitz, like the error that you identified in EOE 544, if that flowed through to any of the schedules, reflect it in late file exhibit 1. So I can repeat that if there are any questions.
Yeah, if you could just, I was trying to make sure I caught it all, but if you could just repeat it,
Okay.
please.
So the company is asked to provide a list of capital projects identified in the rate application as may have been amended with authority approval that are in service as of the close of the record, and also include any adjustments for errors or other information uncovered during the hearings. Okay. Okay, thank you. Then I believe Mr. Bakari is going to kick us off here, please.
Yes, Chairman. Good morning. Good morning, Commissioners.
Good morning.
Good morning, panel. Suleiman Bakari for Parade staff. Please turn to your response to RIU 115, attachment 1 revised. Let me know where you're there.
We're here.
Okay. If you look at Excel row 9, could you explain the 346,000 pro forma adjustment. And why is the allocation for the rate increasing by that amount?
One moment. Mr. Bakari, I'm referencing Schedule CNG WPC 3.18, page 1, which is the
yes.
schedule in our filed revenue requirement that summarizes our computation of corporate service charges. And I see that same 346,000 pro forma adjustment noted there. And as described therein and as further described in our direct testimony, this pro forma adjustment relates to the central facility rent credit due to UI coming out of the authority's decision in docket number 220808. And I can describe that in more detail if that would be helpful.
Can you speak up a little bit? I'm sorry. I don't know if it's the system today, but I think I caught most of that, just if we can.
And I can repeat it if that would be helpful.
Did you hear? Yeah, I'm okay just to.
Okay, I'll speak louder.
Would the company be able to provide all the supporting work papers to determine how the company derived the 346,000 pro forma adjustment?
We can. If you give me one moment, I think we may have described this in our direct testimony and I can check if it was there, but if we haven't, we can certainly provide this. Mr. Bakari, I found it. In the Excel version of the standard filing requirement exhibits that we filed, if you click into the exhibit that I just referenced, Schedule C 3.18, page 1, you can see in the cell the math that we used to arrive at this 346,000, and each of these three numbers are from the authority's order in 220808.
That amount represents the amount being allocated to CNG. My question to you is to provide the supporting work papers as to how you derive the overall amount.
I see. So we can do that, yes.
Okay.
That would be a little too much for me to say out loud right now, but we can provide that table if you have.
Okay, so late file exhibit 2 would be to provide the supporting work papers for schedule. What was that? Schedules?
I understood it to be the total amount of the rent credit being allocated
To CNG.
to CNG.
I'm so sorry. I can't hear either of you. It's so loud up here today.
I'm sorry. I understood, Mr. Bakari, you're seeking the work papers supporting the total amount of central facility rent credit being allocated to CNG.
And include the allocator used to derive the amount that was allocated.
Certainly.
Okay. If you look at staying with the same revised attachment 1, if you look at rows 14 and 15, could you explain if those surveys described in those rows will include activities related to cybersecurity?
Yes, they do include cybersecurity.
Do you know if CNG had its own O&M costs related to cybersecurity?
Its own, sorry, say that again.
O&M expenses that are related to cybersecurity activities.
Can you clarify what you're asking? If
My question is, does CNG separate from the amount that are allocated from the share service company or owning companies. The CNG has expenses on its own that are related to cybersecurity activities.
Direct charges, does CNG have direct charges related to cybersecurity?
What do you mean by direct charges? Does the company incur on its own costs that are related to cybersecurity that are not directly allocated?
Okay, I understand. CNG has cybersecurity charges that do not come through Avangrid Management Company or Avangrid Services Company that are outlined on work paper 3.06.
Regarding the 65,468,000 allocated to URL by Avangrid Service Company, could you explain what portions of those total allocated amounts are for base payroll or for incentives award, pension cost, medical expenses, or fringe benefit? A way for us to get that information.
1 second. So EOE 108 CNG SCG attachment 1 has the detailed descriptions of all the charges that are comprised of the corporate services. And so that breaks out if it's personnel and what the personnel was related to.
And we have an exhibit that aggregates what portion of the amount 65,468,000 for base payroll, incentives award, whether they are cash or stocks awards.
We've definitely done the incentive awards in another filing, but yes, we can put it together and reference the filings that are done. I'm not sure we've done the base payroll, but we've definitely done the incentive.
Okay. If you take the entire allocated amount for URL, I want the amount to be broken down into what portions for base payroll, for incentives award, cash or non-cash, pension OPEB, 401k, medical and dental, fringe benefits, and others.
You want it, just to clarify, you want incentive comp, pension OPEB, 401k, medical dental for all employees that are in the
entire
in the entire 65.
65
Okay.
million.
Yep, understood.
Okay. Turn to your response to, actually turn to SFR Schedule C 2.1.
Mr. Bakari, just one moment. Was that a late filed exhibit
Oh,
request?
sorry, Chairman, that
Okay.
should be a late file.
Okay,
Sorry.
so that's late file exhibit 3. And it's to provide an exhibit that shows what portion of base payroll is allocated.
There show portions of the 65 million allocated to URL. What portions are for base payroll, incentives awards, stocks or non-stock? or cash or non-cash awards, pension OPEB, 401k expenses, medical and dental expenses, and other fringe benefits.
Thank you.
Turn to Schedule C 2.1.
We're there.
If you look at line 38, the allocator for URL for service and building subject to check is 0.23%. Is that correct?
Correct.
Okay. Could you describe the type of services and buildings that are located using that allocator?
Specifically, which buildings? Is that the question that you're asking?
Which building and what type of services are provided in the building that's subject to that 0.23% allocation factor?
Yep. This is all the buildings that have any service company employees. So any company employees that are employees of Avangrid Management Company or Avangrid Services Company who provide services to CNG. So it's the cost of the buildings themselves, either if we own them, the associated costs or the leases.
Would the company be able to provide a listing of all the buildings and a detailed description of the services that are being provided in those buildings and why CNG should be allocated any portion of those expenses?
Yes, absolutely. I think we may have provided bits and pieces of those in other data responses, but we can put it all together in
Okay.
one.
Chairman, that'd be another lead file.
Okay. Let's leave file exhibit 4.
Just to make sure I understand, Mr. Bakari, you're seeking the addresses of the buildings and a description of the services being provided out of them, or?
Precisely, and those in-state and those out-state that are subject to that 0.23% allocation.
I understand. Thank you.
If you look on line 37, could you explain which facilities are associated with the service allocator described on that line?
That's 180 Marshall Road and 100 Marshall Road, the common areas.
And could you explain why 100% of the common areas is being allocated to UIL?
Because those two locations are in Connecticut. So it's the common areas for the employees in Connecticut.
Okay. Does Avangrid service company use the same facility?
Do they use 100 and 180?
Yes.
Yes, they do use 100 and 180.
Okay, thank you. Turn to your response to RIU 115 attachment 2.
We're here.
Okay. If you look at row 11, Excel row 11, could you explain the type of costs that make up the description, executive and governance expense?
This is described in the cost allocation manual that was filed. Just trying to find the reference to it.
Exhibit CNG, SCG, RRP 4. The copy of our cost allocation manual. Within that document, PDF page 30 describes these specific services.
Could you explain why that cost is being directly charged to CNG?
These are the technical services. Oops, that's not that's not referencing the one that you just brought up. They wanted attachment 2, that's attachment 1.
Oh, attachment 2. Yeah, attachment 2. I want 5 years. It's sorry about that.
Do you want me to keep going while okay. So these are the technical services, they're allocated. They're not direct charged. And then row 11. Right, that's what you were asking about?
Yes, thanks. Are those costs directly, indirectly allocated by by Evergreen Service Company or by UIL?
These would be coming from UIL in that pooled methodology that we had described.
The charge type, the network service charge, those are charges arising at Evergreen Service Company level, is that correct?
I'm sorry, when
If you look at the charge type, you describe them as network service.
technical
Technical
services
services, those
Yep.
are costs arising from Evergreen Service Companies. That
or UIL.
so this, just go ahead. I just,
Oh, go ahead.
I was gonna ask you, are these costs arising from UIL or these are costs arising from Evergreen Service Company?
It's the pooled methodology, so technically they're arising from UIL, but these are the technical services.
Okay.
So we separate how we pool down different services, company charges between what we call the corporate services. And the corporate services apply to all of the Avangrid networks or Avangrid family subsidiaries. And then the technical services for Avangrid, we consider to be any of the utility-specific services.
Okay, road 9, could you explain the 136,377 for customer service expense?
I don't see 136 for row 9.
Oh, sorry, that should be for SCG. It's actually 153,800. Was 142,289 for the test year. And rate here is 153,800.
These are the customer services charges. So they're all of the charges that customer service has incurred related to CNG.
Who's providing these customer services? You are providing the customer services, or is Avangrid Service Company providing the customer services?
These ones are Avangrid Services Company providing the customer services. So these particular employees would be customer service employees who service more than just CNG. So they might be servicing CNG, SCG, UI, and this is CNG's allocated share of their services provided.
The customer services employee, do they work for UIL or do they work for Avangrid Service Company?
It depends. They could work for either or they could work directly for the subsidiary itself.
Let's go to row 10. Could you explain why electric operation costs are being allocated to the gas company?
There's an electric operations group underneath one of our vice presidents for Jim Cole, and he runs some gas operations, gas transmission operations, and that's what's coming through for this.
We have work papers supporting how the company determined the electric operation costs being allocated to CNG.
Yep, yeah.
I believe that's late file exhibit 5.
Yes. The gas operation expenses, are those being allocated by UIL or by Avangrid Service Company?
In this schedule, these ones are the Avangrid Services Company, but there could be gas operations expenses incurred at UIL allocated down.
Do we have a definitive answer as to who's doing the allocation for these gas operation expenses?
Like, how is it allocated, or?
Are you indicating some of the gas operation expenses could have been derived from Avangrid Service Company or UIL?
Yeah, either or. They could be derived from either or.
Do we know, how do we know which portion of that amount is derived from UIL, which portion is derived from Avangrid Service Company?
This is the ASC portion per the data request.
So essentially all the costs that are listed here actually are, they arose from ASC, not.
Yes.
It may be helpful, Mr. Bakari, to refer to the original question, RRU 115, which, as we read it, was clearly seeking information at that level.
I knew that, but there was a reference earlier that some of these costs are from UIL. That's why I'm trying to get a clarification as to, because actually on my question reference ASC, but there was a clarification earlier that seemed to indicate some of them have begun at UIL, so. The company is requesting such a new FTE for gas operation in this proceeding, is that correct?
I'm sorry, could you?
Sorry, one moment.
Yeah.
So just one point of clarification, because I think I might have said some confusing items. For corporate services charges, so these are technicals, not for technicals. For corporate services charges, they have to pool. So they have to go AMC, to ASC, to UIL, to CNG and SCG. For technical services, they can go direct from ASC or from UIL.
And do you know if any portion of the expenses in these exhibits are from UIL or all these expenses on this exhibit from ASC?
These are from ASC.
Regarding gas operation, the company is requesting certain number of FTEs in this proceeding, is that correct?
You're asking about some of the incremental FTEs that CNG is requesting in this case?
Yes.
Yes, some of those are for the area of gas operations. That's correct.
Hypothetically, if the authority were to approve all your gas operation FTE, would that reduce any allocation from Avangrid Service Company related to gas operation?
No.
No, the FTEs that are being requested are incremental to all of the current employees that are at CNG and then incremental to any of the employees who are doing work on behalf of CNG, not sitting at CNG.
Would any of the new FTEs that are being requested be working for Avangrid Service Company?
No, they will be CNG employees.
If you look at Excel row 15, could you explain what the acronym OTBT stands for?
Yes, one sec. Operations technology and business technology.
Okay, thank you. Do we know what make up those expenses?
Yes, one sec. There's a group that governs all of like the technology, including some specific like cybersecurity, but any of the across the whole systems that are used as it specifically relates to like networks and networks engineering.
Okay. My next one, row 13, marketing and communication. Do we know what constitutes marketing and communication expenses? What type of communication and what type of marketing is being done at Avangrid Service Company?
These are the technical services from ASC. These would be our communications groups that we have.
Yeah, and the communication group, what do they do? What kind of activities does their job and title entails?
So I can speak broadly to the different types of advertising groups that we have, and we have at least one advertising SME in the audience today. Broadly, there are three different areas of the company that perform communications. One is research and strategic communications. These are communications related to customer accounts, billing, collection, things of that nature, and general information like safety and usage. Second is the customer journey and marketing group. They do things like energy efficiency marketing, gas sales marketing, which are generally recovered through an on-bill surcharge. And then there's corporate communications, things like image and brand advertising, for which we are not seeking rate recovery here.
Okay.
And we've removed those costs via pro forma adjustment on Schedule C 3.18.
Okay. Turn to your response to EOA 376, attachment 1.
We're here.
If you go to Excel row 62, could you explain why the
Sorry, which tab are you in when you say?
sorry, the governing bodies tab. That should be page 6.
And you said which row?
62.
I'm here.
On the road, there's a cost for termination settlement. Could you explain why that amount is included for the rate year?
I don't know, this information might be non-public. Can I quickly check with the lawyers before I say something I shouldn't say out loud?
Sure.
Thanks.
Yes, could we have just a moment to think?
It may be public information, but I'm not sure at this point. So if we can take it as a read-in or potential late filing exhibit, so we can check that and file it under confidential if we need to.
My question is, why is that
I-
expenditure should be incurred for the rate year? I'm
Yep.
not getting into the details of what agreement the company may have.
Yeah.
If this is a one-time recurring cost, should repair be paying for that cost in the rate year? Or should I repair be paying for that type of cost period?
Yep.
Period.
Understand your question, but to describe it, I think I might be disclosing what may be confidential information. So if we could just take it as a read-in later or late file, so we can check that in between.
Chairman.
Yeah, can we, I'm gonna list it as a read-in for now, because I think it could generate follow-up conversation. Can the company check during the lunch break as to whether that is confidential? And I suspect that authority staff are still going to be cross-examining when we come back from lunch. So let's just come back to that question.
Yes, we
please.
can do that.
Okay.
And Mr. Bakari, if it would be helpful, I can offer some general commentary in response to your question without speaking to the line item specifically that we'll check whether it's confidential, but I can, generally, a revenue requirement is developed beginning with a historical test year and then making certain known and measurable adjustments to arrive at a rate year. And in making those known and measurable adjustments, you have to make judgments around whether, is this a one-off item that will or won't recur? Is there something missing from the test year that we need to add? And as I know you've seen, and as we've described, we made a number of pro forma adjustments intended to make our pro forma test year as representative as possible. And we've provided volumes of historical information around the level of corporate service charges allocated to the company historically over time, and also that we expect to be allocated to the company going forward. And while we could sit here and say, this charge will or won't recur, that charge will or won't recur, we've gone through and identified the pro forma adjustments that we think are representative, and we think that we've landed on a level of corporate service charge expense that's representative of the level the company will incur going forward.
Okay. In line with that, do you know if the company filed its 2022 FOC Form 60 in this proceeding?
We filed a FERC Form 60 as an exhibit to the revenue requirements panel. I don't recall if it was the one related to calendar year 2022 or the one filed in the year 2022, but we certainly filed one.
Okay. Do you know when the company will be filing the same FOC Form 60 for 2023?
It's in the process of being prepared. I think it's due end of May.
So during this proceeding, the company will be updating its filing to include that particular Form 60 for 2023. Is that?
Yeah, subject to just making sure I have the right due date at the end of May. We can include that.
Okay. Chairman, I'm not requesting a little file. I'm just asking the company to update the application subsequent to them filing their Form 60 with the FERC for 2023.
Okay. And those updates flow through to, you want them to update it for any affected schedules, or there specific?
If the form was available, that form should have been included as part of the application, but they did not include it. So we asked them to update the application to include Form 60 for 2023. I believe you indicated that the company indicated that they filed for Form 60 for 2022.
Exhibit RRP 5.
Okay. Okay.
Okay, so, is the company clear?
Yeah, I'm just nervous about the end of the evidentiary record, and I'm not a lawyer, so I'll trust counsel to take over.
I'm not a revenue requirements expert, but I agree with what Mr. Hurwitz said. I think the timing of it is such that I think the record here closes on May 24th, subject to check. So I think the question is whether that for Form 60 would be have been finalized and filed by then.
It wouldn't, it's not till the end of May, so it will definitely be like towards the last days of May, not the 24th.
We have no objection to providing it when it's available.
Yeah.
But it would come after the close of the evidentiary record.
Exactly.
Okay.
I stand corrected. It's due on May 1st, so we'll have it before the 24th.
Oh, okay. Okay, so no issue. So that will, so the 2023 for Form 60 will be filed as an update captured under late file exhibit 1. Is that?
We're happy to provide it in whatever venue is
Yeah.
amenable. It was an exhibit to the revenue requirement panel's testimony.
The company filed as a supplement or an update to the RRP 4 that you just referenced earlier?
Yeah, RP 5, but that would be no problem.
Okay, let's file it as a supplement there, please.
Turn to your response to RIU 116 and attachment 1.
My apologies, Mr. Bakari. RRU 116, the attachment?
Attachment 1.
I'm there.
The interim period adjustment of, I believe, 5.742 million. Is that amount simply the 2024 monthly amount multiplied by 10?
You're referencing the $574,186 in cell G19?
Yes.
That amount reflects the sum total of the pension amounts not yet recognized and funded status FVA-PBO. The sum total of those two amounts divided by 12.
But the interim adjustment, what is that just 10 times the monthly 2024 amount?
I see. The 5,742,000 figure reflected in cell F10 of this attachment is calculated by taking the difference between the interim period balance of 10.127 million and the test year ending balance of 5.4 385 million.
Okay. If you look at the balance as of October 2025, is that amount simply 2 times the 2024 monthly amount plus 10 times the 2025 monthly amount?
I think that's right. In effect, our intention was to take weighted average of the calendar year 2024 and calendar year 2025 values provided in the actuarial reports being cited here.
These items are balance sheet items, is that correct?
That's correct.
Okay. Would the company be able to provide a similar worksheet that shows the calculation for both the interim adjustment and the RTA for the OPEB value in schedules, I believe B 8.0?
Certainly. I'd just take one moment. We may have provided that. already.
Okay, if you do, just give me the reference.
Yeah, 1 second.
Okay.
Can't dig that up, but if we are able to dig that up later, we can just point to whatever we filed in our late file.
Chairman, can we have a reading before I request for a late file?
Of course, so I'll make that read in B as in boy. Mr. Bakari, can you repeat?
The company indicated they have provided an exhibit similar to RIU 116 attachment 1 for the OPEB calculation in schedule B 8.0. So I'm asking them to provide a similar worksheet, but they indicated they may have already provided that same exhibit already.
Okay, thank you.
Turn to your response to RIU 145 and attachment 1.
I am there.
Okay. Could you explain if the revenue collected through the term rates are separate and distinct from distribution rates?
They are.
Also, could you explain if in the company last rate case, the authority approved for recovery of term-related expenses in that distribution rate?
I don't recall specifically. What I do recall is that the methodology for the revenue requirement that the company proposed and that was ultimately accepted in settlement agreement with certain modifications was conceptually similar to what we've proposed in this case, in that there was an amount for conservation expenses reflected in the revenue requirement, but also conservation revenues reflected in the revenue requirement such that conservation had no effect on the base rates the company was seeking. In other words, it was in both revenues and expenses in that case, just like we've proposed here. I don't recall if the authority approved something specifically with respect to conservation last time. That I don't recall.
But in this proceeding, you're requesting to recover conservation-related expenses. Is that correct?
I would repeat, I think what I just said, that we've reflected conservation expenses in the revenue requirement consistent with what appears to be the Connecticut historical practice. But we have also included that same amount of revenues such that it doesn't affect the revenue requirement we're seeking.
Could you explain why it is proper for the authority to continue to allow in distribution revenue proceeding revenue related to rate component that have separate reconciliations of their own that are different from the coupling and everything else. Why is that appropriate way to set revenue requirement for distribution rate?
One moment. Mr. Bakari, I don't know that that's exactly what we're asking for. That, as I said, we've included the expenses in the revenue requirement, but it's netted out with the revenues. Again, consistent with what appears to us to be the longstanding Connecticut approach.
When you say it's netted out, could you explain what you mean by netted out?
Sure. Taking a step back at a high level, a revenue deficiency is a comparison between two numbers, how much revenue you need to collect and how much revenue you're going to collect. We've included conservation in both parts, both the revenue we need to collect and the revenue we're going to collect, moving these two items in lockstep, thereby netting them out of the revenue requirement.
Turn to your response to PRA 006.
I am there.
Okay. Prior to the settlement agreement in Docket 180516, could you explain if the company was required to reconcile the allow fee for free program to the actual expenses?
One moment. This particular deferral commenced with the company's last rate case.
So prior to that rate, there was no truing up of the fee for free cost to actual amount, is that correct?
Not to my knowledge.
Okay. And do you know, separate from the fee for free program, do you know if there are other O&M expenses allowing rate proceeding that are subsequently true up in the next proceeding?
Are there other operating expenses that are reconciled?
Yes.
There are a few, off top of mind, hardship on collectibles, COVID deferral, GIS deferral. I guess generally purchased gas expenses are an operating expense. that's
So
reconciled.
check those items that you just listed, those are regulatory assets that you're requesting for recovering this proceeding, is that correct?
Generally, yeah, the PGA, I think, would follow the conservation description I provided earlier, but the other items, yes.
Turn to your response to EOA 209 and attachment 1. My first question to the company is, would you be able to update this exhibit to include, I believe, November and December 2023, and then up to date for 2024?
Probably. I would want to confer with the customer service panel, as I think some of the specific details here came from them, but I'm sure that we can provide some updated version of this.
Okay. You just make a reference to the customer service panel, but I'm gonna ask the question anyway. Do you know why the peer guard service to lower the fees was not adopted prior to 2000, I believe, prior to December 2022?
That question, I think I would have to defer to the customer service panel. I think they could speak to the specifics of the pay guard program better than I could.
But generally, if that service has been implemented, would you agree the regards that being requested in this proceeding would have been lowered to the extent that the actual fees were lowered in period prior to December 2022?
Not necessarily, no.
So what's the purpose of having a pay guide in December 2022?
I think the customer service panel could describe that program better than I could.
Okay, so that was EOE 209 attachment 1 that you want updated for 2023 and 2024 expenses to date.
Yes, Chairman, sorry about that.
No problem. I'm gonna make that a late file exhibit, please, which I think we're up to 6. So Attorney Venor and Attorney Vaughn, if you can help keep me honest, I think what I would like to do, just so we don't get confused, is if there is an error or a mistake that in an underlying interrogatory response, if we can update that. But if it's like a new or add-on request like we just made, I think I'm gonna put that in as a late file exhibit.
Yes, that makes sense.
Okay, thank you.
Can you turn to Pro 016?
I'm there.
We have the attachments as well. There's another attachment. I'm gonna ask this question. We're probably gonna make a reference that should be answered by consumer panel. Do you know why the transaction volume declined in 2023 as compared to 2022?
Do I know why the what declined volume?
The transaction volume, yes.
I'm sorry, Mr. Bakari, I think I will have to defer that one.
Yeah, I just wanted, Puro dash 16, that's sponsored by Ms. Palella, who's on the customer service panel.
All right, thank you. Turn to your response to RIU 311.
Any specific attachment for RU 311?
Actually, no, I just have a general question as
Okay.
to whether the company has filed its, has the company filed its 10K for this, for 2023?
Yes.
And the 10Q for fourth quarter of 2024?
No, not yet.
Okay, can you provide the 10K for 2023 as a late file?
Yep.
And when was the first quarter available, please?
It's getting filed this week. 1 second. Yeah, it should be any day now, but not today.
Okay, so then for late file exhibits 7, then I think we can request the 10K for 2023 and the first quarter of 2024. So I think the late file exhibits aren't due for a little while here.
Yeah, as long as they're not due till May 1st, it has to be filed before then. So
May 1st, yeah.
it will be filed, it's sometime this week. I want to say Wednesday, but
Okay.
In a similar question, as a company file its, in this case, CNG, as CNG's file its, form from 2/4/2023.
no, not yet.
Uh,
Those are due. Yeah, we'll check right now, but I think that's due either mid-May or end of May.
Mr. Bakari, you want to take our lunch break?
Sure, Jim.
Okay, okay, let's take our lunch break and we can come back at 1 PM, please. Thanks.
We're supposed to be under anyway. That's right. Is there any way to raise the button? I just can't. do it.
I raised it,
Really?
but I'll raise it.
I heard it
again.
a little bit.
Yeah,
I
I'll
heard
raise
a
it.
little bit.
I'll put it up even.
So much.
I'll put them.
Thanks.
Okay, we can go back on the record. Let me start by saying, I think I understand the three scheduling administrative matters that were flagged at the start of the hearing. My preference would be to just see how this, first substantive panel, goes, so I can better gauge the, accuracy of cross estimates. But, I think we should be able to ensure that our ROE panel starts sometime on Monday, the 29th. And then the capital investment panel goes sometime next week. And I don't think Attorney Lon's witness issue is going to be an issue, as I don't anticipate getting to that panel this week. So I'm just going to continue to take that under advisement and ask that. I'm going to leave it there for now.
Chair Gillette, I can also report on the issue for witness Hopkins for the OCC. The company is comfortable with Mr. Wheel's proposal to have him appear only once with the on the topic of capital. So if that helps. And then I just have a report back on and a question relating to one of the supplements that we took during the prior cross-examination.
Okay, and on the Dr. Hopkins issue, I'll just say to any other parties listed as reserving the right, I think this is page 42 of the agenda, that the other parties speak now or forever, hold their peace if they have a issue removing Dr. Hopkins from the depreciation panel on page 42. I'm not seeing any, so we'll do that. And then Attorney Venora, was that read in A?
Yeah, well, read in A, the panel is still working to get that information.
Okay.
Earlier in that cross by Mr. Bakari, there was a request relating to the FERC Form 60 2023 data, and we marked it as a supplement to exhibit RRP 5, and which is one of the original exhibits. And I'm wondering if that would be better as a late filed exhibit. Because I'm thinking discovery responses we can easily supplement. Yeah. And so I think that seemed better as a late filed exhibit.
I agree. Thank you. So we'll mark that late file exhibit 8, and it's to provide a copy of the company's FERC Form 60, correct?
It was, yes.
When available.
Yes, when available, correct.
Which is going to be in May, right? I'm sorry, what?
Yeah, so early May, so we'll be able to file it by the first late filed exhibit due date.
By the first one. Okay, that's what I was just going to look up, was whether I need to adjust that. Be the one, I'm sorry, give me 1 second to catch up here. Okay, I see. So the first set of late files aren't due until May 10th. And so we're okay there. Okay. All right. Thank you. So we're still working on the read-ins, including whether read-in A can be discussed in this session or if it's confidential. still?
Correct.
Okay.
Correct. We can provide an answer on read in B.
Oh, okay, great.
We confirm that it has not been filed, so we would be happy to provide the information you're seeking via late file.
Okay, so that would be late file exhibit 9, which is to provide an exhibit comparable to RU 116 attachment 1. Was that?
Excuse me, sorry, I have that, yes, for the OPEB calculation in Schedule B 8.0. In a similar format as RU 116, right?
Yeah, that's correct.
Yes.
Okay, provide an exhibit on the OPEB calculation in Schedule B-8.0 comparable to the format from RRU 116 Attachment 1. Yeah, okay, very good. So I think we're all caught up. Very good. Then, Mr. Bakari.
Okay, I stopped at RIU 311. I think my question was if the company already filed its, in this case, CNG, if it's already filed its Form 2 for 2023.
No, not yet. They're due on May 30th.
Turn to your response to RIU 326.
Are you 326
Yes, please.
there?
Regarding the 724,000 that was paid in the second quarter of 2022, that amount represent the incentives paid to non-union. Could you confirm if there are any portion of the incentives award, of that incentive award, if any of those are paid to officers?
Mr. Bakari, no, this was not for executives or officers.
Okay. Does that amount include portion allocated to CNG by either URL or AMC?
No, it does not include anything allocated.
Could you describe how actually incentives award paid to union? How is that different from the 724? Do you have any quantification of the incentives award paid to non-union in 2022?
To clarify, you're looking for the dollar value of the incentive amount paid to
Yes,
the union?
for the union. If there was any incentives paid to union workers in 2022.
I'd have to check. We very well may have provided that in discovery, but I don't have that offhand.
Okay.
We could look for a moment. That would be helpful.
Chairman, I would actually like to request for a late file. And the company should provide an Excel worksheet that shows the total incentives paid both in 2022 and 2023. The total amount should be broken down for amount applicable to union and non-union. The company should also quantify amount paid to officers for either cash or non-cash awards. And they should also indicate if any of the total amounts allocated to CNG are from either the shared service company or the holding companies.
Mr. Bakari, do you mind if we break that down into some chunks? Because I think we've provided a good amount of what you just described on the record, and I just want to make sure we get you the exact information that you're seeking. So this data request response, which you've just pointed us to, provides the amount of CNG and SCG non-union executive compensation Our response to OCC 145 provides by plan the amount paid to CNG's Greenwich Union, CNG's Hartford Union, and also the non-union payment. And then we've provided a number of other data request responses regarding executive compensation, which itemizes the different types of variable compensation paid to our executives by plan type. I just want to make sure we get you exactly what you're looking for.
I would still like to have an exhibit that summarizes the total incentive compensation that was paid in 2022 and 2023 to be broken down for those components I just described, which are total pay to unions, non-unions, quantified amount paid to officers, either for cash and non-cash awards, and then to indicate or quantify portion that are allocated to CNG by either the holding company or the shared service company.
Okay. That'd be LFE 10.
Yes. Okay, I'll turn to response to RIU 328. Attachment 1, page 5.
RRU 328, attachment 1, page 5.
Yes.
I'm there.
Could you,
Ours doesn't look like the screen though. Yeah, that's what ours looks like.
look at the $10 million for special contract and ads in the interruptible sales. Could you explain why that amount will remain the same for the rate here?
Mr. Bakari, this response and also this attachment were sponsored by our rate design panel, and I think they might be better able to speak to the contents of this presentation than I am.
Okay. You're saying the company does not know, or this panel does not know what portion of the total revenue requirement are generated from non-tariff rates?
We've provided information in our initial filing with respect to the amount of revenue we expect to receive from a variety of sources, including base rates and non-base rates. But the revenue requirement panel looked to the rate design panel for those inputs. I'd be happy to speak to non-firm margin generally in our proposals with respect to non-firm margin, but if your question is, why is this number $10,009,328 instead of $10,012,000, just to make a number up, I think that would be best addressed by the rate design panel.
Are you familiar with some of the terms in some of your special contract or with your special contract customers, or does have to be addressed by the revenue panel as well?
I'm broadly familiar with special contracts, but if your questions are really in any level of detail, I think they would be best addressed by the rate design panel.
Okay, my question to you is, do you know if any of your special contract have any adjustment escalation to them or not?
I would have to defer that one.
Okay. Turn to your response to RIU 313.
This one was sponsored by the tax panel.
The question I'm gonna ask actually has to do with the revenue impact of these responses, not the calculation of the tax himself. For calculating your revenue requirement, do you know if CNG normalize or flow through the deferred income tax impact of repair tax deduction?
Subject to check, I understand the revenue requirement reflects normalization for this item, but I think that would be best discussed with the tax panel.
Do we know how much RTD was estimated for the rate year?
How much, what, I'm sorry?
Repair tax deduction is estimated for the rate year.
One moment.
Okay.
As a general matter, Mr. Bakari, that is computed in what we have termed the plant model. It was provided as an exhibit to the revenue requirement panel's testimony, and we're just pulling that up in case you'd like us to explain that in more detail. But broadly, that calculation can be found in our pre-filed plant models.
My question to you, what was the RTD amount for 2023? I know the company does file is RT, what you call it, the plant model with the application, but how much is the total RTD for 2023?
RTD is short for repairs tax deduction.
Yes.
So again, Mr. Bakari, I think the tax panel could speak to the details of this filing more specifically than I could, but my understanding is that the actual amount of repairs tax benefit taken by the company that relates to calendar year 2023 would be identified in our filed tax reform, which I would not expect to be filed for some time. But again, our tax panel could describe that more specifically for you.
Just to confirm, earlier, I'm sure I'm going to reserve the right for your tax man. You indicated that for RTD, the company normalized the deferred income tax effect of repair tax deduction. Is that correct?
Generally.
Okay. Turn to your response to RIU 327.
There.
Okay. Now, if you go to Excel row 1494 and 1495,
Which attachment?
just attachment one. Sorry.
Sorry, which Excel rows and attachment one?
1494 and 1495.
Bless you. We're here.
Okay. Could you confirm if any of those costs in those rows were allocated to CNG?
Yes, they would be.
Okay. Are those costs arose from Ibadrole?
Those particular costs? No.
Turn to Excel row 8 through 23.
Curry, were you referencing 8-23 or 8,200?
No, the X 8 through 23.
Got it. We're there.
Could you discuss the building depreciation expenses on that line? Explain which buildings are being depreciated?
So the depreciation that's outlined in here is supported by EOE 109 that discusses which specific buildings are being depreciated for CNG and SCG.
Are those buildings owned or leased by Avant-Garde Service Company?
Or Avangrid Management Company.
Similar to my question earlier, would your company be able to provide a listing address of those buildings that are leased and owned by either Avant-Garde Service Company or AMC that are subject to this depreciation allocation?
Yes.
Okay, I believe we are up to the file exhibit 11.
Yes.
Mr. Vicari, just so, I heard you provide a list of owned or leased buildings with depreciation and other related, I did.
Expenses allocated to CNG. If we look at Excel 205 and through Excel 243, building asset management, could you describe the type of asset or building that fall under this allocation?
This isn't buildings, this is the personnel for general services. So that's the group that services all of the buildings. And we have a description of what the general services charges are and what services they provide in the cost allocation manual.
Okay, turn to turn to your response to RIU 667 and the attachment.
I'm there.
Okay. If you go on page 1, subject to check, in January, the credit balance that's not been refunded yet, I believe is 139,260.
My apologies, Mr. Bakari, 139,260. Where are you?
That's for January 2023. The last column, I believe.
I see that.
Okay. Could you explain why in February the company refunded 257,379 if the balance as of January was only less than 140,000?
One moment. I can. As we described, I think in our rebuttal testimony and potentially a couple of data requests as well, the CNG was in earnings sharing in this year and proposed returning that earnings sharing to customers over the period October, November, and December of 2022. And we proposed a specific rate designed to return a specific amount of dollars based on the expected sales in those months. The authority approved the amount of earnings sharing that we were proposing to return to customers, but changed the give back period to December, January, and February, but left the rate the same. So the company continued returning its over earnings, but because of seasonality and volumetric differences, and the heating season is much more overlined with December, January, and February than October, November, and December. It resulted in a different amount being returned than what we calculated, and we're proposing to, in effect, true that up here.
As part of the company's compliance filing, did the company made the authority aware that by misaligning the refunding period from October through December to December through February, that might actually increase the amount to be refunded, that the actual rate for refunding should be reduced to reflect the sales for the refunding months?
Candidly, I don't recall what sort of compliance filings we had to make following the authority's response to our motion.
But the company could have made the authority aware that the refunding rate for ESM is larger because you apply sales for 3 months that is significantly less than the period for which the refund is taking place. Is that correct?
As I recall, we submitted in a data request response, there was some language in the authority's order in docket 220808 indicating that rate cases are the appropriate venue for resolving deferred balances.
Turn to page 2 of the same filing, please.
I'm there.
Okay. Substitute check. It appears the refunding here was done in October through December, not December through February. Is that correct?
Certainly what it appears here.
Okay. Can you confirm if CNG has filed its ESM compliance for 2023?
CNG and SCG have both filed their earned returns for calendar year 2023, and both companies were below the threshold for triggering earnings sharing. One reported an earned return on equity of 8.21%. The other reported 8.41%. I forget which is which, but both are below the threshold for the earned for earnings sharing. We may have filed a letter indicating that earnings sharing is unnecessary. I don't recall, but we filed the earned ROE report, certainly.
Can you file that same compliance for CNG in this proceeding? Or do you want the authority to take administrative notice of your filing in the 760307 docket?
The Data requests that Mr. Wheel pointed Mr. Canavan to earlier extend through calendar 2023. Subject to check. I think that's OCC 687 and 691, somewhere in that range. They extended through 2023 and provide the ROEs I quoted a moment ago.
Okay.
691, I'm being told.
691 attachment 1, yes. Okay. Turn to OCC 162, attachment 1.
I'm there.
Given the company assertion that corporate allocation approach was transitioned in 2018, 2019 timeframe, explain the significant increase in the internal legal expenses allocated to CNG in 2022.
One moment.
What you're looking at are probably outside legal expenses. We probably have to look at the actual response itself. So,
We have that as well. Apologies, we're just researching your question.
And just to confirm with the panel, there was a revised version of OCC 162.
Thank you for the patience, Mr. Bakari.
yeah, no problem.
In OCC 512, subpart C, we described a planned reorganization, moving the claims department from the customer services group to the legal group in 2022.
Okay.
That is the primary factor driving the increase you noted in the revised response to OCC 162.
Okay. What type of expenditure make up the internal legal expenses?
What type of expenditures make up the internal legal expenses?
Those payrolls for internal lawyers and legal personnel and things like that.
This would be primarily labor and labor-related costs.
Okay. Now, if you turn to the attachment one on the screen, could you explain the 73,482 adjustment in 2022?
The $73,482 labeled
Yes.
just adjustment. This relates to injuries and damages. And we sponsored a small handful of responses on this indicating that the rate year amount of injuries and damages we're seeking is 0.
Okay, thank you. Turn to your response to actually strike that. Turn to SFR Schedule H 1.1.
$1.1,
Yes.
I'm there.
I would go to page 46.
PDF page 46.
46 of. Yes.
I'm there.
It might be that page below that, 46 of 157. If you look at the chart just at the top of that page, could you discuss if any of those reg assets impact the rate base requested in this proceeding? Or the amount reported for the test year?
Yes, a handful of these are elements of the company's proposed rate base in this proceeding.
Which particular one are you referencing?
I'll go down the list. Pension and other post-retirement benefit plan is an element of both CNG and SCG's proposed rate base. There's a pension-related asset on Schedule B 6.0 and a OPEB-related liability on Schedule B 8.0. Hardship programs are, one moment, let me just confirm. Hardship-related deferrals are reflected on Schedule B 6.0 of CNG's proposed revenue requirement. Unfunded future income taxes would be reflected on Schedule B 7.0 of the company's proposed revenue requirement. Deferred purchase gas costs would not be an element of the company's proposed rate base. Revenue decoupling deferrals would not be an element of the company's proposed rate base. System expansion reconciliation would not be an element of the company's proposed rate base. And then other, will depend on exactly what's in there.
Okay, Mr. Erwis, could you read the paragraph just below that chart that you just referenced?
Would you like me to read it out loud?
Yes, please.
The one just below?
Yes.
Pension and other post-retirement represents the actuarial losses on the pension and other post-retirement plans that will be reflected in customer rates when they are amortized and recognized in future pension expenses. Because no funds have yet been expended for this regulatory asset, it does not accrue carrying costs and it is not included within the rate base. Pension and other post-retirement benefit cost deferrals include the difference between actual expense for pension and other post-retirement benefits and the amount provided for in rates. The recovery of these amounts will be determined in future proceedings.
Does the second sentence in that paragraph align with the company assertion that pension reg assets is included in rate base?
I think that, one moment.
So just to clarify, like Mr. Horowitz said earlier, he said a component of the pension and OPEB is included in rate base. There's two different aspects of rate base. There's of pension and OPEB. There's the piece that we actually have cash payments for. And then there's a portion of it that's based on actuarial gains and losses that is deferred. And eventually what happens is the piece that is related to actuarial gains and losses, they eventually turn into expense. And once it turns into a cash expense, that's what's included in rate base.
The 52,574 reported here, is that a component of what is reported in your schedule B 6.0?
There's the 574 there, and then there's a regulatory liability on the next page for pension and other post-retirement benefits of about $2 million. The rate base piece is gonna be different than those two. So the amount that's in rate base is 4.3. I'm sorry, there is 4.385 in the CNG revenue requirement model in B 6.0.
Turn to page 47. Could you discuss if any of these liability on this page affect the company rate base for either the test year or the rate year?
Let me just check on one item. Again, I'll go in order. Pension and other post-retirement benefit plans is subject to that same discussion that we just had. Asset removal costs and asset retirement obligations, we would expect to both be elements of accumulated depreciation, that component of rate base. Rate credits, subject to check, I think ends before the beginning of our rate year, so they're not an element of our proposed revenue requirement. Tax reform and generally all accumulated deferred income taxes are an element of our proposed revenue requirement. Non-firm merging, we included this amount in our historical test year, but then removed it via pro forma adjustment for reasons we've explained in a handful of data request responses, including OCC 426 and OCC 671. Hardship programs are, and then other, again, will depend on exactly what's in there.
The asset cost removal, would you consider that to be a reserve account balance?
That's the cost of removal that's in the accumulated depreciation account for our FERC form for US GAAP reporting, which is what this is showing. We move that credit from accumulated depreciation and put it on the liability side of the book.
Does that represent the cumulative amount that the company already recovered from ratepayer for future cost removal?
Yep, exactly.
So then my question to you is, do you consider that a reserve?
I would consider it under the US GAAP definition of what cost of removal should be, which is amounts that have been collected from ratepayers that if not spent need to be refunded back.
That amount, is that amount reflected as an offset to rate base in this proceeding?
That's the amount that's in accumulated
That's how
depreciation.
much in accumulated depreciation, okay.
Mhm.
Go to page 50, please. If you look the DIT related to goodwill, is that included in the rate base for this proceeding?
No, it's not. And in fact, you can see it being removed from rate base on Schedule B 7.0 Excel row 20. That same 5,727,000 you see on the FERC form is also shown in our ADIT computation schedule.
There was a pro forma adjustment to remove that from.
Yeah, we put it in the test year column, but you'll see it's labeled less and it's subtracted out.
Turn to your schedules H 1.1 and H 1.3.
Any particular pages?
No, I just have a general question if the subject to check, I believe this proxy statement is for 2021.
Correct.
As the company file its proxy statement with the SEC for 2022.
Yes.
Why was that not included as part of the company's application?
We filed the letter that was filed during the test year. We'd be happy to provide the more recent one.
2022 is your test year.
And we filed the one that was filed during the test year.
Can we update or have a solidify your proxy statement for 2022 in this proceeding?
Yes.
Of course.
Okay.
Okay, so late file exhibit 12 is to provide the 2022 proxy. Is that what you're looking for?
Yes, proxy statement, yes.
Provide the 2022 proxy statement.
Chairman Gillett, that's all I have.
Thank you. Great. All right, Mr. Pfaff.
Good afternoon, panel. My name is Ryan Paff, and I am a consultant to Pura and Pura staff. I see a lot of familiar faces. I think I met most of you in Docket 220808. So it's glad to see you again. And I don't think my questions should take too long, but I did want to confirm and clarify a few things that I've seen in your filing. The first area I'd like to discuss is cash working capital. And I would like you to open Schedule B-4.0A work paper. Excuse me. And if you can open the Excel worksheet, that would be helpful. And yeah, I got okay, yeah, it's on the screen there as well in PDF. But this is a work paper showing how the company derived its cash working capital allowance. Is that correct?
Yes, that's correct. And just to clarify, from a revenue requirements perspective, we took the leads and lags calculated in Mr. Adams's lead lag study and then determined where and how to apply them in the revenue requirement. And that's the schedule that you see here.
Understood. And when you say determined how to apply them, did you make any modifications to them or did you take them directly from the lead lag study?
The leads and lags, which is the days involved in either the time between when revenue is charged to customers and recovered or when expenses are incurred and paid. Those are all calculated in the lead lag study. We imported them without modification into the revenue requirement study.
Okay. And that would be the CWC factor, correct? That's the one that's driving the calculation. Or I should say that's the input from the lead lag study that is driving the calculation here.
Yes, that's correct.
The bottom of the rate year 2024, 2025 column of this table is the total cash working capital allowance being requested by the company. Is that correct?
For CNG, yes.
Yeah, for CNG. Usually when I say the company, it's obvious, but here I appreciate the reminder to be precise with my language. So the calculation on line 17 is for the cash working capital related to federal income tax, and the calculation on line 18 is a cash working capital related to state income tax. Is that correct?
Yes, that's correct, with the clarification that these are the current portions of income taxes.
Mm-hmm. So as I was looking through the spreadsheet, it appeared to me that the calculations on lines 17 and 18, and I've got them highlighted there, appear to have the federal and state income tax cell references reversed. And I wanted to ask if you had the Excel sheet in front of you, if you would be able to check that and see if you agree or disagree with my assertion. And if you don't believe you can do it quickly, we can potentially have it as a read-in.
I think we can do it quickly.
Okay.
Just give us 1 second. Thank you for your patience. So my colleague, Mr. Hurwitz, did confirm that the dollar amounts that are applied for federal income taxes and Connecticut income tax on line 17 and 18 are flipped, where the federal dollar amount applied in that schedule represents the state piece and vice versa.
Okay. And just a clarification question related to that. Would they be entirely flipped, or would the CWC factor, or I guess I'll ask it this way, is the CWC factor also flipped? Or is it just the reference to the C schedules?
And we'll double check that real quick.
It's not my intent to put you on the spot either. So if you have to take a second, I think we could do it as a read-in as well.
And I appreciate that. I think it should be pretty quick.
Okay, thanks.
So Mr. Paff, I did just confirm it's only the dollar amounts that are flipped. And so the lead lag factors that are imported from Mr. Adams' study are aligned with the description.
Okay. And would this be something that would be corrected in the companies update.
We'll
Okay.
correct this in LFE1.
Okay, thank you.
For highlighting it.
Thank you. Is Mr. Adams available? Because I have some questions for him.
He is? Yes.
Okay.
And I'll just offer as he comes up, Mr. Paff, as I described, Mr. Adams calculated the leads and lags in the cash working capital study. On the revenue requirement side, we applied those to dollar amounts. So there may be some instances where I'm answering a question depending on the questions you ask.
I understand. Thank you.
Yeah. And just for the record, Mr. Adams has been sworn.
Thank you.
Good afternoon, Mr. Adams. My first question is related to the narrative response that you provided in RRU 651. I've put it on the projector, but in this response, you were asked to state why the average billing lag increased from 1.5 days in the company's prior rate case to 2.88 days in the instant case. Do you remember that response?
Vaguely, yes.
And could you briefly describe what the billing lag is and how it impacts the company's working capital calculation?
The billing lag is the elapsed time between when the meters are read and when the bill is sent out to the customer.
And all else equal, a higher billing lag would result in a higher working capital allowance. Is that correct?
Depending upon dollars, yes. Depending upon the dollars,
How would it depend on the dollars if all
everything's,
else is equal?
everything is weighted, so it's weighted based on dollars.
So there would be a scenario where you would calculate a higher billing lag and it would actually result in a lower working capital allowance.
Yeah.
Yeah, I was asking if there would ever be a scenario where you would calculate a higher billing lag and all other factors held constant, it would result in a lower working capital allowance.
Generally, I would agree with that, yes.
I'm sorry, just to make the record clear, are you saying that there would not be a scenario that you can think of where calculating a higher billing lag would result in a lower working capital allowance and another way of saying it is all other factors held constant, a higher billing lag results in a higher working capital allowance. Is that accurate?
All other factors are constant and the billing lag is higher. The overall cash working capital required and would be marginally higher.
Okay, thank you. And did you say marginally higher? Sorry.
Well, billing lag is not that big of a impact on the cash
Mhm.
working capital. So
I wasn't sure I heard you.
my voice is going.
It's the start of the week, so Okay. So you were asked about the change in the billing lag from 1.5 days to 2.88 days. And you ultimately provided RRU 651 that corrected this amount and reduced the 2.8 days to 1.44 days. Is that correct?
Yes.
And can you summarize the reasons for why the correction was necessary?
I believe the correction was made because in the original calculation, the wrong information was pulled to calculate the lag. So that was corrected.
And it was the manual meter read data was used instead of the electronic meter read data. Is that correct?
Yes.
And was this just an inadvertent omission? It wasn't your intent to initially use the manual meter read data?
No, it wasn't.
Okay. And using the average number of days from the electronic meter data, which takes the billing lag from 2.88 days to 1.44 days, that, again, all else equal, will lower the company's working capital allowance, correct?
All other things being equal, yes.
And in response to subpart A of RU 651, you state that the company will reflect this change in its next cost of service update in this proceeding. Would that be LFE 1?
It would.
And will the company be providing an updated working capital analysis, including a fully updated lead lag study that reflects this and any other corrections that it may have?
Mr. Paff, what we had contemplated was just updating that B 4.0 schedule you pointed us to, but it wouldn't be a problem to update the study for this, if that would be helpful.
Okay. And could that be incorporated into LFE 1, perhaps?
Sure.
Okay. And just have that lead lag study and whatever other working capital analysis is supporting the updated working capital figure.
I just make sure we're on the same page about what counts as the working capital study.
Sure.
'Cause I think there was some testimony and a few exhibits that accompanied Mr. Adams. And I just want to make sure we provide exactly what you're looking for. I'm picturing an Excel file, which I've coined MJA3 in my head. Is that what you had in mind, or were you anticipating something more fulsome?
Let me Let me look at that. Yes, NJA3, correct.
Should be no problem.
Okay, thank you. Okay. My next series of questions is related to the payment lag that was used. Mr. Adams, this question I assume will be for you. In the instant case, you used an average payment lag of 1.0, but in the previous case, the company used an average payment lag of 0.5. Is that correct?
That's correct.
And similar to the billing lag, would it be accurate to say that all other factors held constant, a higher payment lag results in a higher working capital allowance?
Yes.
In the request to RRU 652, you were asked to provide the underlying calculations, source data, and reasons for the proposed increase in payment lag relative to the prior case. Is that correct?
That's correct.
And in your response, you state that the difference between the 1.0 payment lag and the 0.5 payment lag is that in the prior case, the company assumed a 0-day lag for certain payment types, such as Kubra, but you assumed a 1-day lag. Is that correct?
Yes.
You go to page 26. So since Kubra has the highest weighting, about 50% of the payment processing for CNG, I actually looked on Kubra's website and I found a couple of statements made on their website that seem to conflict with a 1-day payment lag. And I'll just go through these quickly. Here, this is essentially an FAQ on Kubra's website. It says, how fast will my payment arrive? And the response is that your payment will generally be reflected. Oh, that's actually a different page, but there's a statements on Kubra's website that says, how fast will my payment arrive? And the response is that your payment will generally be reflected in the biller's system immediately. There's another section that discusses, can you go to page 26 again? Yeah, so this section references real-time processing. And it says the Kubra Easy Pay point of sale solution allows customers to make payments and immediately receive validation of payments, account information, and confirmation. And then there's another section that's specifically related to utility customers where it talks about real-time processing. So my question to you is, do you know why the company is not receiving real-time payment processing if it appears that it's available to other Kubra customers?
And Mr. Paff, can we see that other section, please, that you were describing?
Which section is that? Sorry.
You said there was another section that described utility payments.
Yes, that would be page. Give me 1 second. That'd be page 28. Yeah.
Mr. Paff, I just want to note for the record that the document you're showing is not in the record, and I don't know if there's any equivalence between what you're showing and what the company's actual arrangement is with Kubra. So I think we can try to answer your questions, but I don't think we necessarily agree with the premise that, or we know the extent to which these services are available to Kubra, other than taking this at face value. So.
I'm sorry, maybe if you could repeat the question.
Sure. So my question was, if you know why the company is not receiving real-time payment processing from Kubra, if it appears to be available to other Kubra customers, and obviously if you don't know, then that's a fine answer.
I don't know, you're pulling something from a website that I have no way to validate, but the information that I used is based on the company's processing of the payments.
Okay, that actually dovetails nicely with my next question. Could you please turn to page 4?
And Mr. Paff, we will have the customer service panel here, and they can answer details about the company's actual arrangement with Kubra to the extent this panel can't do so.
Okay, thank you. So, Mr. Adams, when you were asked for the source documents related to the payment processing calculation, you provided this spreadsheet, and on the spreadsheet, it has descriptions of the different payment method providers, processors, and for Kubra, it says that there's a self-posted customer account occurs in real time, and actual payment post to customer account and overnight processing for the next business day. Can you define what soft post is?
I cannot.
Okay. So did you get this information directly from the company?
Yes.
And is this what you relied on for purposes of making your payment processing, payment lag related assumptions?
This would have been one piece of information, but we also had discussions with company personnel about when the funds were actually available.
And did you have a way to independently verify that?
Just looking at the data that was provided to us, it did not break it out by source though necessarily.
Okay. And if it didn't break it out by source, how would you know for certain that the Kubra payments were not available to the company?
That's when we went back to what the company had told us.
Okay. So you relied on the company for this?
That was the point of verification, yes.
And a follow-up to the reliance on the company or clarification of that is that you relied on this specifically from the company for verification about these different payment providers' processing times.
In terms of the payment processing times, yes, we relied on the companies
Thank you.
and the data that we had reviewed, so.
So the data that you reviewed did not break it out by payment processor, correct?
That's correct.
So how would you have used that to?
In this case, it wouldn't have worked, but I was speaking generally to the working capital, so.
Thank you. One of the payment methods is is for wires and ACH payments, correct?
Yes,
And what was the payment day lag that you assumed for wires and ACH payments?
it was one day.
Can you tell me why you assumed one day when in the processing time it states that wires ACH payments are processed to customer accounts the same day?
The data we relied upon calculated it, so it would have rounded up over half a day, so we rounded to one day.
And what was the data that you relied on? Because I thought we had just discussed how this was the information that you relied on for the payment processing times.
It was this information, so it's typically when they receive a payment, it takes time to process it. So we wrote, it was rounded up to one day.
So could there have been a scenario where you would not have had a processing time of at least one day if the company's information states that it's processed on the same day and you still assumed a 1 day lag?
Can you repeat that?
Sure. I might rephrase it actually and make it a better question, but I'm trying to understand how if the company is stating to you that that these payments are processed on the same day, and you, as you described, round that up to a day, how there would ever be a situation where the processing time for a payment method was anything less than a day, even if it was instantaneous.
That's all I can, the only way I can answer the question. This is data that was provided to us or information provided to us by the company. This is a very small portion of the overall receipts and processing of the payments. And the one day isn't going to make a great deal of difference on the cash working capital overall requirement. So based on our discussions with the company, we assigned it the lag that we have there.
Thank you. Moving on. In your rebuttal testimony on page 13, beginning at line 4, you state, if Pure decides to exclude non-cash items from cash working capital, it should exclude all non-cash items, as this would be the only reasonable approach. Do you see that statement? It's also projected, if that's easy.
Yeah, we have that.
And I understand your theoretical argument for this, but I wanted to understand the mechanics of what you were describing as well. When you say that if Pure decides to exclude non-cash items from cash working capital, it should exclude all non-cash items. Are the non-cash items or I should say, by non-cash items, do you specifically mean the list you included on page 5, lines 16 and 17 of your direct testimony? And this would be the list starting with uncollectible expense.
So I'll start, Mr. Paff, because this is one of those instances where we were applying the leads and lags to the amounts in the revenue requirement to determine the cash working capital allowance. And I think you said you understand the theory, but I just wanted to restate it. So generally, there are 2 broad approaches to conducting a lead lag study. One that focuses on only O&M expenses, and that's called generally the O&M approach, and another that focuses more broadly on a broader view of the income statement. So it includes things that we are calling non-cash, which are non-cash from an accounting perspective, but have real-world cash implications to the company in terms of it taking time for them to recover those costs. And it also includes things like operating income. And then there can or cannot be offsets to operating income related to, for instance, dividend payments or payments of interest. So that's the theory behind it, is that there's 2 broad approaches. Regulatory commissions tend to pick one or the other. The O&M approach which is the approach that has not historically been used in Connecticut, I would say is a blunter approach to cash working capital. Still valid, still relied on by regulators, but it just looks at just that O&M bucket of costs. Historically, looking back through the orders of PURA, there's been a sort of delicate ecosystem built around cash working capital where more of the broader view of the income statement has been looked at, and that's included, again, we're calling non-cash items here. So things like depreciation, deferred taxes, uncollectible account, amortization, and then operating income would be the other one. And with offsets related to the payment of dividends and interest. So long way of saying, I think the non-cash is a bit of a broad name for that approach because it considers the entire income statement and attributes cash working capital implications to each item.
I'm not sure you directly answered my question, so I'll restate it.
Sure.
But by non-cash items, and I'm attempting to use Mr. Adams's terminology with this so that the record is clear. But by non-cash items, do you specifically mean the list you included on page 5, lines 16 through 17 of your direct testimony, starting with uncollectible expense and ending with retained net income?
That appears to be comprehensive. We did just file a supplement to a data request that addressed this more specifically. So if you give me a minute, I'd like to pull that up. And my apologies, I'm not readily finding it. So, but just looking at this list, I think that it is comprehensive and matches what we said in that supplemental response.
Okay.
And I might just clarify, just looking at that on the screen now, that says dividends paid from net income. As I described, the calculation of the non-cash / income statement approach starts with operating income as a lead lag item. And I think that's called retained earnings in Mr. Adams's study, and then also reflects offsets to operating income, such as dividend payments from net income.
And Mr. Dane, the supplemental response to discovery that you were describing, what is included within that?
It is the response to RRU 437. And the question asked for, the question was asking about the differences in O&M versus non-O&M approach. And so the supplement, as stated in the initial response, Mr. Adams performed the non-O&M broader approach in his study. And so the answer was no, that the company had not performed an O&M approach. But in preparing for the hearing, we thought it would be helpful to prepare an estimate of the O&M approach. And so that's what the supplement's intended to accomplish.
And how did that impact the working capital, cash working capital allowance calculation?
And we provided that information in an attachment to the supplement. I think in each case, it was a downward adjustment to cash working capital. As we described in that supplement, if you go from an O&M approach to a non-O&M / income statement approach, it could vary for a variety of reasons. It's really driven by what the expenses that you're applying it to are. In this case, moving to an O&M approach, which would be a divergence from historical practice in Connecticut. As we estimated it, that was a reduction in cash working capital.
Do you know what the reduction is that you calculated?
I do. We provided that in an attachment. So for CNG, our estimate of using the O&M approach was a reduction of 6.2 million in cash working capital.
Okay, thank you.
And I'll just add that one of the points that we made in this response, which I think is an important one, is that the importance of consistency. So sticking with a method, one approach may provide a higher or lower answer in any one case, as I described, for a variety of reasons. And I think just for purposes of the companies providing an approach, if the authority were to determine a different approach is warranted, which we wouldn't agree with. We think the method that it's established over time is appropriate, but we just want to relay the importance of sticking with one method over time for consistency.
Understood. Thank you. My next series of questions is related to the plant model. Could you please turn to page 13? Am I correct that the plant model is essentially a collection of linked spreadsheets that the company uses to derive its plant-related inputs for its revenue requirement model?
I generally agree with that description.
Will the company be providing an updated plant model with its response to LFE1?
We intended to, yes.
Obviously, the plant model is a very large spreadsheet with about 30 tabs and thousands of active cells. So given the size and complexity of the spreadsheet, how does the company ensure its accuracy?
It's an iterative process. I think to begin with, it starts with a model that's been used in prior cases and also used by the company in other jurisdictions, and then builds on that as necessary to be jurisdiction specific. And working with a team, we recognize that there are a fair amount of calculations in the plant model. Ultimately, it's designed to calculate plant and service, depreciation, deferred taxes, and some income statement impacts, and then to flow those into the revenue requirement. So I don't think the concepts are higher level in nature, but recognizing that there's some intricacies in those calculations, it does take a team to put it together, review it, and ensure its accuracy.
And because it is so, because it is such a critical calculation, I want to make sure I understand the vetting process that you all go through. Are there validation checks, automated validation checks embedded in the plant model? And if so, can you direct me to those? I wasn't seeing that exactly.
I'm just going to pull up the plant model. And Mr. Paff, if you're referring, for instance, to an error check cell or something like that, we do not have those in the plant model. That's a process we go through as part of the checks and balances to check those verifications, but this version does not have built in, for instance, an error checks tab or something that that would highlight any issues.
Okay, and my question somewhat stems from my experience with large and complex spreadsheets and the fact that if there's a plus sign instead of a minus sign, that's potentially millions of dollars one way or the other. So I'm just trying to understand exactly the process that you all go through and how you probably first of all get a comfort that the plant model is materially accurate, and then beyond that, refine it to the point where you feel comfortable that it's completely accurate.
Maybe I'll jump in for a second. As Mr. Dane described it, it is an iterative process. There's a draft prepared, reviewed, feedback, another draft, and so on and so forth. But there are a few high-level things we do and have done to make sure that we have comfort in the results of this model. One, which you can see some remnants of on the tab labeled 2, beginning plant balances, are we reconcile to the FERC form. We make sure that the plant balances reflected herein are not exactly the same, and there are some reasons for that we can get into, but consistent with what's in the FERC form. Another example is in the overall structure of the plant model. One thing you might notice in this plant model that wasn't present in the one we filed in 220808 is there's a tab called Summary RR Input, which contains in one place all of the outputs of the plant model that then flow into the revenue requirement model. And we felt that sort of modeling simplification made it easier to avoid those plus signs that should be minuses, because we put everything in one place, in one easy to export location. Another example of a sort of high-level check that gives us confidence in the results of this model is studying the results of rate base by month. And we provided a data request response. I forget the number, but summarizing that output, you can study, are there jumps, are there things that don't look right? And then there's, of course, the mechanical checks, which Mr. Dane described. We don't typically include in our filed Excels, but we do go through a rigorous process to make sure that the pluses that should be pluses are pluses, and the minuses that should be minuses are minuses.
And with these validation procedures, would they be memorialized in writing?
Nothing so specific as this is our procedure for verifying the plant model, but there were, I'm sure, emails and back and forth that like resulted from that process. Some of it was in meetings, some of it was in calls.
Yeah, sorry, after you. I was going to say a rate case takes a while to pull together. So as something like the plant model gets developed, there's a hypothesize, test, and validate process where as we update assumptions, we need to hypothesize about what's going to change. And then as those get flowed through, we need to test and then validate whether the change that we thought would occur did or didn't. And then if it didn't occur, ask why, and that's the source of validation. And so as Mr. Hurwitz was describing, at those checkpoints, we would then get together as a team over Zoom typically, or Teams, to just talk through the model as it developed. But I think that's an important check, is as inputs get updated, as the case gets finalized, just the rigor around making sure that the results still make sense and meet our expectations.
And do you perform sensitivity analysis, for example, including, or I should say, changing one aspect of the plant model and having an expectation of, okay, if we change this input, it's going to change this output by X amount, and making sure that it is doing such, because my fear, and the reason why I'm not fear necessarily, but my purpose for going through this process is just to make sure that we can feel comfortable that there isn't a formula error on tab 24 that cell, C 1002, and that you all are not intending to do, but it can be an inadvertent thing. So that's why I'm trying to understand this.
Sure. And that stress testing happens in the process I was describing, where as assumptions that feed into the model get finalized, we would put them in. And if a dollar amount changed, does the result that comes out of the model make sense? If a depreciation rate gets zeroed in on a basis point or two difference, does the change make sense? And so I understand your point of view. It is a large spreadsheet. There are thousands of calculations in there. You had mentioned, could the model be off by millions or tens of millions? Those would certainly be things that we would catch as part of the initial process. And then as part of that validation, as we go through and update assumptions, zeroing in on the final product, that tolerance for error becomes slimmer and slimmer.
Could I ask for a late filed exhibit that provides a description of the validation procedures performed on the company's plant model, and also requests any supporting documentation and or proof of the validation procedures? And for purposes of this response, you can limit the validation procedures and the supporting documentation to the plant model that you're going to provide in the update.
Sure.
Okay, that's late file exhibit 13.
I next have some questions related to shared services. If you could please turn to page 28 of the revenue requirement panel direct testimony.
Page 28.
Correct.
I'm there.
Table 5.
I see it.
It appears that there is an approximately 8% escalation factor to the shared services to derive the rate year amount from the pro forma test year amount. Is that correct?
It is correct. 8.09% to be precise.
And that's reflective of the standard inflation factor, correct?
That's correct.
And is the inflation factor the only change between the pro forma test year amount of shared services and the CNG rate year amount?
Between the pro forma test year and the rate year. Yes, that's correct.
Okay. And what are the dollar amounts associated with the inflation adjustment for the corporate shared services for CNG? Is it simply the 18.025 minus the 16.676?
That's how I would have calculated it, yes.
Okay.
I can do that math if that would be helpful.
No, no, that's fine. And the test year pro forma amount is derived by using the actual test year shared services costs and removing certain expenses such as branding, sponsorships, et cetera. Is that correct?
A couple of our pro formas added costs, but conceptually, yes, it's the test year plus pro forma adjustments gets you to the pro forma test year.
And what are the shared services pro forma amounts that added costs?
I said that thinking of the central facility rent credit, which I mentioned earlier. The company recorded, or excuse me, CNG was allocated an amount for the central, the rent credit paid by the service company to UI. In docket 220808, the authority found that that amount should have been higher. And so we've included a pro forma adjustment to reflect the flow through effect of those findings on CNG.
Okay. And when you said you referred to that earlier, was that with, in response to
That Bakari, it came up in discussion with Mr. Bakari.
Okay. Can you please turn to attachment 1 of RRU 448?
I'm there.
Do the pro forma adjustments shown in this attachment represent the full amount allocated to CNG for these line items? Or are some amounts in these categories still being sought for rate recovery?
Sorry, I'm not sure I understand your question. Could you ask that again?
Sure. The categories listed on, and I can bring it up so I can give you an example. Give me 1 second. So for example, the branding and communications category, do these represent all the costs that had been allocated to CNG or just a portion?
Thank you for clarifying that. That helps. RRU 448 is intended to, one, capture all of our pro forma adjustments, and our pro forma adjustments were not intended to be partial. We're not seeking some other amount for this type of costs elsewhere in the revenue requirement. Rather, we intended to fully remove them.
Okay, thank you. Could you please turn to the response to RRU 449, attachment 1?
I'm there.
Could you explain the reallocation of technical shared services between CNG and SCG, and as part of the explanation, describe why it was necessary?
Yeah, one moment.
In the 2022 actuals general ledger, there was a misallocation of the Massachusetts formula of what actually got allocated to CNG versus SCG. We noticed it and we fixed it in the test year to correct the allocations that are going to CNG and SCG to be exactly what they should have been per the Mass formula for technical services. And this flip only happened on the technical services that are allocated. So said another way, we're adjusting the general ledger to be the correct amounts for the test year.
Okay. And were the allocations to CNG and SCG reversed? Is that what happened?
Correct.
Okay. You turn to attachment 1 of OCC 176, please.
We're there.
The rate year amount that is listed in column I, is that the total board of director cost that is still included in the revenue requirement?
Yes.
So for CNG, that amount is 174,000.
Yes.
And that includes an inflation escalation factor.
It does.
Okay. For investor relations, it's 87,000, and that also includes an inflation factor. Is that accurate?
Yes, that investor relations number is all in, so personnel benefits, any external costs that are incurred by investor relations, but that's the cost of having investor relations.
And so the amount embedded in the revenue requirement is the 87,000. Okay,
Yes.
thank you. Can you please turn to attachment 1 of RRU 780?
I'm here.
Is the total audit fees included in the requested revenue requirement for CNG? Is it 750,124, or is it that multiplied by the inflation escalation factor?
One moment.
Mr. Paff, the amounts noted on RRU 780 CNG attachment 1 are test year amounts. So you would have to inflation adjust them. I'll clarify that of the $750,124, the amount stemming from Excel row 8 direct CNG audit fees are reflected on Schedule C 3.06. Whereas the amount labeled intercompany external audit fees to UIL from ASC are reflected on Schedule C 3.18 and included in the broader bucket of corporate service charges. But yes, you would have to inflation adjust.
Okay. And if you inflation adjusted that for the 8.09%, that's the amount that's embedded in the revenue requirement. Is that accurate?
That's the amount embedded in the rate year revenue requirement.
Rate year revenue.
Yeah.
And I assume that that same logic would be applied to the brand and communications category. And so everything that you just described for the audit fees, as far as it being the test year amount and having to adjust it using the escalation factor, would be the same for this category. Is that correct?
I see why you would think that, but no. We have removed these costs via pro forma adjustment. You can see that reflected on Schedule C 3.18, page 1, line 9, where we removed $242,000 for branding and communications.
Okay. And is this, well, I'll ask you this. What was the basis for removing that?
We chose not to seek recovery of these costs.
What was the reason that you didn't seek recovery for the costs?
Um, one moment, I'm
So we had responded to that in RRU 780. And we've interpreted brand services as the same services as were disallowed by the authority in docket 220808. And we remove such costs from its proposed revenue requirement via pro forma adjustments. However, as described further in the response to RRU 802, we have not removed costs associated with a different set of services.
Can you describe the brand services that you did not remove and the reasons why?
We did describe that in the detailed data response. One moment, let me just pull it up.
Thanks.
So that's further described in RRU 802.
I've got that up.
The licensing, this is the charge for licensing. Do you want me to read this or?
If your answer would be exactly the same as
My
it is here,
answer is
then it's,
exactly the same
then
as
it's
it is here.
unnecessary.
Yeah.
Thank you. Could you please turn to attachment 1 of RRU 115?
And Mr. Paff, we filed a revised version of this attachment according to my records. Are you referring to the revised?
Yeah, I don't think that it should, no, it doesn't matter. I don't think my question was impacted by the revision, but you said revised, yeah. So my question is related to the second line item that's listed there, which is the serve dot in building. And there is a relatively large pro forma adjustment of 346,000 related to this item. Can you first explain what this line item pertains to and then explain the reason for the adjustment?
So services in buildings would be described in our cost allocation manual, and Ms. Van Lulling could describe that in more detail. This particular pro forma adjustment is that central facility rent credit that I mentioned before. It's the same 346,000 stemming
Okay.
from 220808. And I think we committed to provide a late file. I've already lost track of late file 2, which provides the details of that computation.
Can you now please turn to pages 24 and 25 of your direct testimony? And specifically, I want to discuss figure 2 on page 25.
I'm there.
So on figure 2, you detailed the phase out of the corporate capital charge related to the cost of shared assets that are now reflected on the books of CNG and SCG. Is that correct?
That's correct.
What are these shared assets?
Generally, these were shared capital assets held at the UIL level, which were for the large part IT related assets.
Okay. In the $16.8 million in rate base, was that meant to be illustrative, or is that a CNG amount or an SCG amount?
This was a CNG amount as of a particular point in time. Obviously, over time, assets will depreciate, and the amount of property tax they attract, the amount of interest, income tax, et cetera, they attract will all change. My recollection is these were intended to reflect the actual values used to establish CNG's last revenue requirement. So in the docket number 180516, there was some amount for the corporate capital charge reflected in that approved revenue requirement. This is intended to sort of disaggregate that for illustrative purposes.
Okay. And so what it essentially did is let me say it this way. The figure is meant to be illustrative as you described, and it takes the charge that was embedded in rates in the previous rate case, and it translates that into how it is being recovered in this case.
Almost. I think generally you've got the right idea. This figure is intended to show how the one lump sum charge in the last case, the 5.8 million, had we applied the method today, would have been of a different nature, but the same total. We would not have had a $5.8 million charge reflected in our corporate service charges. Rather, we would have had 4.1 million of depreciation, 0.1 million of property tax, 0.3 million of interest, et cetera. So those amounts in that right-hand column aren't exactly what's in our proposed revenue requirement because time has passed and
Of course.
but I think subject to that caveat, I think that is the idea.
And I perhaps misspoke before, but it illustrates the methodology that you're using in this case. The figures would obviously be different.
You got it.
And the company notes that this change is neutral to customers, correct?
Correct.
And how does it verify that?
I think this figure is intended to show that. I think if you were to look at the work papers supporting the computation of the corporate capital charge, you'd see it really is just as we described, that there were assets held at the UIL level for which CNG and SCG were charged their allocated share of the revenue requirement. Those same assets then, following the phase out of the corporate capital charge, were pushed down to the books of CNG and SCG, and those same costs that used to be allocated are now recorded directly on the books of the operating company. So I don't know if you had something particular in mind when you said verify that, but that's sort of what we were thinking as we said that.
Well, when I say verify, I mean the revenue requirement model is different for rate base than it is for O&M, for obviously. And So how does the company know that if the corporate capital charge was being used in this case, it wouldn't vary from how the ultimate revenue requirement or the ultimate how the ultimate revenue requirement would be calculated? If that makes sense.
I think it does. At its most basic level, we know that because this is just the simple transitive property multiplication. You know, do you do the multiplication at the end of the line after you've calculated the full revenue requirement and then you're allocating just a piece of that revenue requirement? Or do you do it at the beginning of the line when you're recording the assets on the books of either UIL or CNG or SCG? And I think, you know, we all know the transitive property for multiplication, it doesn't matter the order. What we could do is we could impute what the revenue requirement would have been for these assets and like recreate counterfactually the corporate capital charge, but we didn't go through that exercise here because like I said, you know, the numbers are the same. It's just a matter of which operating company they get recorded to. I guess I'm just struggling to come up with what else we could do to verify.
So it goes from the UIL rate base. I'm just looking at your figure right now. It goes from the UIL rate base of 116 million to the CNG operating expense of 5.8 million. And is that based on the cost of capital that was used?
The 5.8 million would have reflected, and this was actually, I think, one of the settlement adjustments in that case was to make sure that this occurred. That reflected the approved cost of capital in that proceeding. The 5.8 did.
Okay.
Maybe if it would be helpful to you, we could provide an Excel file, which is just taken strictly from the record of the 2018 rate case to illustrate how the numbers are the same. I want to help in the quest for verification.
I think that would help.
We can do that.
Yeah,
Absolutely.
let's do that.
Okay, so we'll take that as a lead file exhibit, which would be 14. And Mr. Pfaff, do you want to try to summarize that for me, please?
Sure. Excel sheet from the company's previous rate case that demonstrates the revenue requirement calculation of the corporate capital charge.
Okay.
And that concludes my questions. Thank you.
Okay, very good. Let's take a quick break until let's go like 3:15. Thanks.
Wow.
Yeah. Yeah.
Thank you. If we can find our seats, please. Okay, let's go ahead and resume cross. I think we are up to Mr. Kewalder or Mr. Pfaff. Did you have anything? One more. Okay.
I just had one more question. Can you please go to the company's response to RRU 537?
I'm there.
In this response, the company states that in consideration of Senate Bill 7, which I believe is also referred to as Public Act 23-102, correct?
My understanding is I've used those terms synonymously.
Okay. That the company's removed certain expense types in consideration of Senate Bill 7 from the revenue requirement, but did not remove other expense types that are reasonable and necessary for the operation of the business. That's a quote from the company. Is that correct?
That's correct.
Can the company provide a late filed exhibit that quantifies those expense types that were addressed in Senate Bill 7 that the company did not remove because it deemed them, quote, reasonable and necessary for the operation of the business?
Yeah, let me just take one moment. We may have provided that already.
Okay, thank you.
Oh, the responses I was thinking of were RRU 453 and 454, which sought for expenses incurred at the CNG level and expenses incurred at the service company level and then allocated to CNG respectively. The amounts reflected in our proposed revenue requirement for a long list of expense types, inclusive of entertainment expense, relocation, communication expense, travel and training, industry dues, and there are a number further. Would that satisfy what you were looking for, or would you still like us to prepare the slate file?
Well, would this be a comprehensive itemized list that quantified any and all expense types addressed in Senate Bill 7 that the company did not remove from its revenue requirement? Or would this be something slightly different?
This does clearly denote what we did and didn't remove from the revenue requirement. I'm just, I suppose it's possible that the list of things contemplated in Senate Bill 7 differs slightly from this. I haven't contemplated that specifically.
Well, the company stated that it did consider Senate Bill 7 when putting together its case, and it removed certain expenses from the revenue requirement, but it did not remove other expenses that it deemed reasonable and necessary for the operation of the business. So
My apologies. My caveat on comprehensive was in reference to RRU 453 and RRU 454. We were going off of the list of specific costs that were provided to us in the request. If that makes sense.
okay. So I think to be safe, I would like to make this LFE request.
No problem.
That's acceptable.
Okay, so late file exhibit 15 is to itemize and quantify any and all expense types addressed in SB 7 Public Act 23-102 that the company did not remove from its revenue requirement.
Correct. And that concludes my questions. Thank you for your time.
Thank you. So we'll move to Mr. Cadwalader next.
Thank you, Chairman. Good afternoon, Commissioners. Good afternoon, panel. Steve Cadwalader with Bureau staff. If I could refer the panel to CNG's response to RRU 151, referencing security deposits.
I'm there.
Is the interest rate on security deposits set by Congen Stat Section 16262J?
If you just shrunk Connecticut general statutes down into an abbreviated form, yes, that is the Connecticut general statute reference that I have.
Okay, and has that rate been at an annual rate of 1.5% since 2002?
That's consistent with my recollection.
Okay. And if I could refer you to your response to RRU 153?
I'm there.
How do the companies expect the test year volume of mail to compare with the rate year volume of mail?
One moment. Could you actually repeat your question? I forgot exactly which way you asked it.
How do the company expect the test year volume of mail to compare to the rate year volume of mail?
Thank you. As described in our rebuttal testimony, the rebuttal testimony of the revenue requirements panel, starting at page 28, we described that we expect the rate year volume of postage to go down. Excuse me, volume of mail upon which we purchase postage to go down.
Great. And do you know what the trend has been since 2018 through the test year for the volumes of mail?
I don't recall that specifically, unfortunately.
That's something that could be a read-in, perhaps.
I suspect that could be tracked down, yes.
Okay, so that we read in C.
And just to make sure I have it, you're seeking historical trend in volumes since 2018.
Right.
Got it.
And also, maybe as part of that read-in, if you could take a look at the average volume of mail over the 5 years and compare that to the rate year volume.
Okay.
And if I could refer you to the response to RRU 155.
there.
Is the plan move from unleaded fuel to diesel fuel to biodiesel fuel expected for both CNG and SCG?
It is.
And why is that move being done?
I would have to confer with an SME at the company who's not here today to provide a more fulsome explanation. But my understanding at a high level is that that move is being done as part of the company's broader ESG initiatives. It's an effort to, in effect, diminish the environmental impact of our vehicles.
And has any of the cost or benefit from that move being reflected in the rate year?
To the extent that move had not occurred in the test year, no, it's not been reflected in our proposed revenue requirement. Rather, the proposed revenue requirement reflects the company's test year transportation expenses adjusted for the general inflation escalation rate.
So this particular move is not part of the rate year filing?
That's correct.
Okay. With regard to return on rate base, is it fair to say that changes in rate base impact the revenue requirement, is impacted by the revenue requirements by the company's pre-tax cost of capital as opposed to its after-tax cost of capital or even its weighted cost of capital?
You might have lost me in your question.
Yeah, I think I lost myself as well. With regard to the changes in rate base, is it fair to say that the impact on revenue requirements is the company's pre-tax cost of capital as opposed to its after-tax cost of capital or even its weighted cost of capital?
So maybe I'll answer that by taking a step back. Changes in the rate base reflected in the revenue requirement have a handful of effects on our proposed revenue requirement. And you're correct, those effects include both the effect on our return, our after-tax return, and also by extension, the amount of income tax expense we would impute. And I think that's what you were getting at with the pre-tax, after-tax WACC distinction. But then
I'm thinking if you change rate base, say by $100, would the impact of that $100 increase in rate base be a revenue requirement that includes the pre-tax cost of capital to the company?
That's right. You would include the pre-tax return. And I would just highlight that changes in rate base could or would affect other elements of the proposed revenue requirement as well, including the uncollectible expense gross up and the gross earnings tax gross up. So it wouldn't be quite as simple as that, but conceptually, yes, you would use the pre-tax WACC.
And there might be a depreciation impact as well.
Yes.
If I could refer you to the response to interrogatory PURA 049.
I'm there.
Is the conclusion drawn in the response to that interrogatory the result of assuming that the return on rate base is equal to the discount rate?
Yes, that's a key assumption that produces this conclusion.
And if the rates were different, then the net present values would be different between the two scenarios. Is that a fair conclusion as well?
I would say changing the rates would change the analysis. To be precise, it is theoretically possible that it could result in the same conclusion, but it would change the analysis.
In particular, if the discount rate is lower than the return on rate base, would the offset to rate base have a higher net present value than the flow through the PGA?
I'll just need to think that one through with you.
If the discount rate is lower than the return on rate base, would the offset to rate base have a higher net present value than the flow through the PGA scenario?
if the discount rate were lower than the return on rate base, customers then, or it would be more advantageous to give the money later. Because you place less of a time value on your money. Conversely, if it were higher, you'd want the money sooner.
Great, thanks. Your Honor, I'd like to have a late file exhibit where the company would provide a supplement to the response to interrogatory PURA 049 using the company's pre-tax cost of capital as the return on rate base and a 7% rate as the discount rate.
We can mathematically provide that, but from just a principle of corporate finance perspective, I would stress that it's important that the cost of capital used to compute the revenue requirement is on the same tax status as the discount rate used to discount the cash flows. In other words, I think it would be inappropriate to compute pre-tax cash flows and use an after-tax discount rate.
With regard to the return on rate base, that's what the company requires for increases to rate base, right? The company's cost of money.
No, our cost of capital is just that, our cost of capital.
Right, but the discount rate could be a rate that ratepayers view as the appropriate discounting of revenues they have to pay out, dollars they have to pay out. And so they're not necessarily the same. Is that correct?
I'm with you that a pre-tax and an after-tax discount rate are not going to be the same. But I think what I'm trying to highlight, and we can do the math and then explain this logic in our late file response, but it's important that the discount rate is matched to the cash flows being discounted. And so if you're calculating pre-tax cash flows, you would then have to use a pre-tax discount rate to properly discount those cash flows. And conversely, if you're using an after-tax set of cash flows, you would need to use an after-tax discount rate to properly discount those cash flows.
Agreed, but this could be a pre-tax requirement of the companies versus a pre-tax requirement of ratepayers. And not necessarily, the rates may not necessarily equate.
Sorry, I'm not sure I understand the question.
Ratepayers may have a different discount rate than the company does.
That's fair.
Okay, if we could have that late filed, Your Honor, and the company can feel free to put in whatever caveats it wants to with regard to the supplemental.
Thank you. That's late file exhibit 16.
Your Honor, that's all the questions I had.
Okay. Thank you, Mr. Bacalina.
Good afternoon, Jim Vocalina for Pura staff. I have a couple of follow-up questions. I'll start with brand services. I believe you testified that the company has removed the direct communications and brand services cost from its request. Is that correct? The amount of $242,000?
That's correct. We did make a $242,000 pro forma adjustment related to image and brand advertising.
Okay. And there was some further talk about amounts that remained in there, and that would be the allocated portion. That's $511,000 in RRU 454.
Correct.
Okay. Can you explain the differing treatment between the direct and the allocated?
Sure. So as described in RRU 802, the $511,235 that was left in the revenue requirement is the licensing charge, which we paid to Iberdrola because being part of the Iberdrola family grants us the access to different technologies, global supply chains, and business opportunities that serve as mitigating factors related to risks associated with CNG. It also helps us to attract high-performing employees by affording them the opportunity to work on a global scale and providing unique career growth opportunities. The branding costs that were removed were the CNG-specific branding costs.
Okay. Now, to be clear, the licensing that you talk about does not relate to licenses that Iberdrola pays for software, et cetera, things of that nature. Is that
Correct.
correct?
That's correct.
Those costs are included elsewhere in the service charge.
That's correct.
This is for the, I will call it, goodwill. If I could use that term of, the company CNG, being able to avail itself of these things that you mentioned, at the Iberdrola level.
I'd say it's more the ability to use the Iberdrola name.
Okay. All right, thank you. There was also talk about the direct audit costs. And the direct audit costs are $730,000, which I believe are increased for inflation. Also, the company is requesting an allocation of approximately $80,000 for allocated costs for audits. Is that correct?
Yeah, that's correct.
And what is that audit? What audit service is that?
Sure.
80,000.
So KPMG currently are the auditors of Avangrid. Avangrid Networks in the year that is the test year, and then the subsidiary CNG and SCG. And what happens with an audit is first they're gonna do the Avangrid audit, and they're gonna pick certain samples, and they're gonna test certain accounts. And in their samples and accounts, some of them are gonna be CNG and SCG related. And so when they get to the standalone audit, they've already tested some of that from the Avangrid consolidated audit, and they don't have to redo it again. So they just pull the work papers out from what they had already done for the Avangrid audit and carry them forward. So they may need to do 30 samples for CNG, but they've already done 5 at the Avangrid audit. And so they take credit for the 5 and then they supplement another 25. The direct portion is the supplemental piece to get to the full audit. The allocated piece is the allocated share of the example of the 5 that I'd given.
Thank you.
You're welcome.
And these amounts both refer to year-end audits.
Yes, they're
Okay.
year-end audits, yep.
Are there any other audit services provided in the revenue requirement outside of these amounts here?
There's internal audit. That's
That's-
included.
That's performed with in-house?
Yes,
Okay.
and that's less, they do some financial audits, but they also do operational audits and they're true in-house internal audit function.
Okay, thank you. Two questions on training. Well, actually, yeah. ROU 795, please.
The attachment or the,
Yeah, it's, I'll go through the various attachments. I'll start with attachment 1. Items 1 and 2 specify creation of training materials. Does the company create these training materials on a yearly basis, or is this something that would serve for multiple years?
One moment, we'll confer with the training SME. We refresh them periodically depending on when they need to be refreshed.
Items 6 and 10, CNG projects, gas O&M, and training, operations training, make up a significant portion of this, but are only identified in 2 line items here. Was the company unable to break those down any further?
As you notice in Excel column C labeled order, you have a very confusing series of numbers there. Most start with 9800 or 9400. Those refer to internal orders in our accounting system that we use to track costs. And so this attachment was prepared at the internal order level. And as you've noted, the majority of the costs that relate to training were recorded to those couple orders.
Okay. Attachment 2, please.
RRU 795.
Oh.
I have just one attachment.
Sorry, 799, attachment 1. I moved on.
All right,
Sorry.
keeping us on our toes. I'm there.
Line 2 there, simply the term credit there appears, is that actually a credit that is going in the wrong direction?
I am not sure. I would have to look into that.
Okay. You just want to read that in, or?
1 second.
Okay.
See if we have that. We may need to take a read in, unfortunately.
Okay, no problem. Sure.
We're up to D.
Yeah, let's see, training credit, RRU 799. Sorry, that was letter.
Excuse me, D is in dog.
Okay.
Mr. Buckley, is that page 2 of the attachment? Just so I'm.
Yes. Also, miscellaneous training, staying on the same exhibit, 799, attachment 1, page 2. Miscellaneous training expenses allocated of $26,000, not separately identified to materiality. What was the threshold that you used to determine materiality for these particular expenses?
I don't recall. You'll notice again that this attachment is similarly constructed at the order level, and we went through in each order, and for I don't know how many there are here, a couple dozen, we identified to the greatest extent possible. Even for those items, I see items of $189, $151, $204. We tried to ascertain and provide as much description as possible as to the nature of the costs underlying those amounts, and this bucket is for everything else.
I'm on 799, page 3 or 4 now, attachment 1. I have electric redesign projects on here as item 2. Could you explain that?
We looked into this in preparation for hearing, and I was told what this was.
You're ready then?
I cannot recall, unfortunately. Just frantically searching. Bacalina, the word and is missing here, electric and redesign projects. And that's important because these are redesign projects for, and this is embarrassing, I was just 1 second ago told what these trainings were, but these are trainings that benefit all avant-grid operating companies, inclusive of the gas companies, and it's not just electric specific, it's broader trainings.
Thank you. So I noticed the fifth item down appears to relate to flight training. Is that similar in vein to removing the corporate aircraft? Would that be something that the company would agree should not be in there?
Which line item again?
I guess it's 6, actually.
Company would agree to remove these.
Okay, thank you. I'm going to bring my laptop for a CG. I won't. Because this is, I believe, tab 3 of 799, page 404, or still attachment 1, I'm sorry, page 404. And this may very well be the same answer that you had previously regarding electric training, or no?
I think this electric training would be the same story as what I described earlier. It's poorly labeled, but these are for general corporate-wide trainings that are not electric specific.
Okay. R58. Turn to 458, please, RRU. This is a direct CNG training, not allocated, is that correct?
One moment. Bacalina, your question was, is the company's training exclusively at the CNG SCG level, or rather, is there some training allocated to it through the service company charges, or?
I believe there's training allocated. There's both direct and allocated. The amounts are what is shown on 458. Is that both or direct and allocated, or is this only direct?
Are you referencing a specific amount that I'm just not seeing?
Well, there's no particular, this just goes over the various trainings on here. I was going to ask for any amounts associated with these, but my initial question is, does this relate to the training expense that's on 453 or 454 or a combination?
I think broadly, and we struggled answering some of the training questions for this reason. Our training group isn't exactly designed with that in mind. Rather, there's what we call technical training that collaborates with pertinent lines of business to determine course offerings and identify what groups should be trained. That is provided to CNG and SCG employees specifically, and then also employees of other operating companies, although we're not asking for that today, obviously. And then there's more company-wide trainings for the types of things denoted in attachment 1 here. Just the acceptable use policy, the anti-market manipulation, et cetera. These are all, for the most part, the company-wide, avant-grid-wide trainings that are allocated through corporate service charges.
Okay. Would it be possible to determine the amount that you have allocated for, if these in fact are on 458 corporate allocated as well as direct, the amounts attached to each of these forms of training that you have here in 458? And I assume that would equal what you list on training direct on 453 and allocated on 454.
The amounts would be what we said in our RU 453 and 454, that there wouldn't be a different bucket of costs.
Okay, and to the extent that you could isolate items that are listed as discretionary on here and amounts allocated or dedicated to those items, I would ask for a late file exhibit for that.
We're up to late file exhibit 17.
So that's amounts for discretionary or discretionary training, RRU 458.
We can absolutely take a shot at that. I think there are going to be limitations on our ability to line up dollars with exactly these categories, but I think I understand where you're trying to go, and we can take our best shot at that.
All right, thank you.
And we will caveat our late file as necessary.
Okay. Staying with RU 454, relocation expense. Would the allocation of that, would that be reflective of a 4.08% allocation that's mentioned in G 2.12? Is that how the allocation of relocation expenses are?
It depends on who the underlying employee is.
Okay. In terms of, so it would not be as simple as looking at the 72,000 divided by a 4.08 to figure out what a total Iberdrola or affiliate number is?
Yeah, it wouldn't be that simple. It depends on where the employee who's relocating, what company they're assigned to. So if they're ASC, then the portion that CNG is going to get, it's going to go ASC, UIL, CNG.
Okay.
But if they're a CNG employee that's relocating, then 100% would be.
Okay, and that may lead into this next late file exhibit, which could explain what you just mentioned there, as well as the company policy with paying relocation expenses, whether they're direct or allocated. And I guess you could put in a late file exhibit, you could answer here how the company works to contain these costs.
I might suggest that in the compensation and benefits panel, we address that because that's one of the benefits for
Okay.
new hires. But we can definitely address it there.
And Mr. Vocalina, we did provide the company's policy as an attachment to our rebuttal testimony.
The relocation expense.
The policy,
Oh.
yes. That was exhibit CNG SCG RRP rebuttal -4.
Thank you.
Sure.
All right, I'll cancel that late file exhibit for the time. Sorry, there's one more question. There was one more question. It has Mr. Langland as a witness. Would you care to attempt to?
We can give it a whirl.
Okay. It's RRU 794. And essentially, the response indicates there's a 3-year qualification period. Now, the company has increased expenses in this area, approximately $100,000, I believe. Does the 3-year qualification period, since they're performed every 3 years, my read of that responses, are the training staggered over the 3-year period, or does the request reflect all of these trainings in the same year?
We may need Mr. Langland, but he is in the room. We're hearing that they are staggered.
Okay, thank you. Those are my questions. I believe Mr. Cadwalader has another.
Okay.
Regarding bank fees expense, which is the response to interrogatory RRU 154.
$154. RRU 154
Right.
there.
Is the credit card expense rate the same between the two companies?
The rate year amount of expense that we're seeking is not the same. But I think the customer service panel could better speak to the composition of those rate year amounts.
I'm looking more at the expense rate that the credit card company charges the company, whether that's the same rate per bill paid by credit card or debit card.
There are a wide variety of different rates. My understanding is that they do not differ between CNG and SCG, but I think the customer service panel could provide far more detail on that than I.
Right, thanks. Thank you, Chairman.
Thank you. Attorney Keenan?
Going to be asking questions regarding outside legal services. But before doing so, I have some follow-up questions from earlier today. My first question is follow-up on testimony Mr. Hurwitz provided to Mr. Bakari regarding the company's response to interrogatory RRU 667, which is regarding ESM. And for clarification, during which months did the company return to customers the customer portion of the 2023 ESM amount? and why?
Ms. Keenan, CNG returned earnings sharing amounts in January and February of 2023. We also returned amounts in December of 2022, but your question was in 2023, it would have been January and February. You asked why, and it's because the authority ordered us to do so in response to motion number 38 in docket number 180516, and that's described on page 44 of the revenue requirement panel's rebuttal testimony.
You said motion number 38?
Yes.
And that, okay. Okay, thank you. My next question is follow-up on testimony provided regarding CNG's plant model. What is the source of data inputs into the FERC form?
The company's general ledger.
And is that the same source that's used for the plant model?
Generally, yeah.
Ms. Keenan, I would just add that portions of the plant model are forward-looking. So those would be based on, for instance, plant in service projections, as opposed to what would be in a historical FERC form.
Thank you. My last follow-up question is regarding training materials. And the company testified that it refreshes training materials when it thinks they require refreshing. Is there criteria that you use to determine when refreshing is needed?
One moment, I'll confer. There isn't a hard and fast rule. However, there are certain things that would cause us to develop new training materials, including, for example, a new tool being developed that our operation groups needs to use, a new regulation with which we must comply, or as our training materials age, we may look to update them and refresh them, but there isn't a hard and fast, we update this every 5 years or 10 years. It's not like that.
Okay, thank you. And now I'm going to turn to outside legal services. And my first question is regarding Schedule CNG WPC-3.06. And in the schedule, the company reports $1,000 for the test year and $75,000 for the pro forma adjustment. In footnote 5, however, the company states that the pro forma adjustment was made to remove non-recurring litigation provision adjustments. So should the 75 be a removal?
No, although I see why that would be confusing. Here, the key phrase is provision adjustments, and those can be upward or downward. As I described earlier, this amount, which is the same as, I want to say it was OCC 162, which Mr. Bakari was showing us earlier. This is really related to injuries and damages, and we've removed those amounts from the proposed revenue requirements of both CNG and SCG. If you look at the same schedule in SCG's proposed revenue requirement, schedule SCG WPC 3.06, line 2, you'll see that same line with the same footnote is a downward pro forma adjustment of $312,000. It's the same concept, same GL account. It's just their provision adjustments were in different directions.
Yeah, the remove, it's a bit confusing. Okay, and my next question. It's just clarification regarding interrogatory OCC 162 in the attachment. In the response, the company states the pro forma adjustments for the non-recurring legal expenses in the test year plus a little over 1,500 for year-end accrual. The year, in looking at attachment 1 is the adjustment for the year-end accrual included? There's nothing listed.
One moment.
And I'm trying to understand what the amount of the non-recurring legal expenses are.
But a couple items. First, OCC 162 CNG attachment 1 does denote certain accruals in Excel row 12. Second, you can see the Excel row 11 in that same attachment, which we reviewed earlier today, is labeled adjustment in the amount of $73,482. I've opened the Excel version of our initially filed revenue requirement. It's an Excel file titled CNG revenue requirement model filed version. And I've gone to the schedule you referenced us to schedule C 3.06 WP. I've clicked into the pro forma adjustment in question. You'll see in that cell that same $73,482 and then 2 other adjustments all baked into that same cell. One upward adjustment of $5,799 and a downward adjustment of $4,141. Those 2 amounts are the accruals being referenced in OCC 162.
Okay, so everything's captured in that 73.
Yes.
Okay,
yes.
Thank you. My next question is regarding the company's response to RRU 461. Can the company confirm whether a company, affiliate, subsidiary, or its parent participated in the state or federal appellate matters that the company participated in calendar years 2016 to 2023? I'm trying to figure out for each appellate matter in which the company participated. Can you confirm whether an affiliate, subsidiary, or its parent also participated?
One moment. Ms. Keenan, we're not aware of any current appellate matters which would meet that criteria. In the time period you requested, I think the EDF litigation, which we've discussed in our direct testimony and a couple of data request responses. I'm not sure exactly what counts as an appellate matter, but there was litigation, and CNG's affiliate SCG would have also participated in that litigation, but generally we're not aware of other instances of this.
And the EDF litigation is captured someplace else in the application.
That's correct. That's correct.
Sorry, the EDF litigation is captured someplace else in the application.
That's correct. We described it in our direct testimony. It's one of the regulatory assets we're seeking to recover here based on a settlement agreement of a previous PGA proceeding. I could describe that further, but
What would typically cause a parent, affiliate, subsidiary to participate in litigation that the company is involved in?
I think the word typically is tricky because these things seem to be few and far between. But I can confer and see if we can get more guidance there.
And I'm asking you this because you say in response to the interrog, you say usually the only time would be when usually relate directly to the company. That's what all of yours is, but you didn't say only. So I'm trying to.
No, I appreciate that. And generally CNG and SCG would only join a litigation if they were named. And as I mentioned, it's not common. So CNG would not join litigation just because an affiliate was participating. CNG or SCG would have to be named parties.
Okay, thank you. My next question is regarding the company's response to interrogatory RRU 465. Can the company confirm that other than the costs associated with this rate case, it does not seek recovery in its rate case application of any amounts associated with the use of consultants or outside counsel retained by the company to support its participation in a docketed proceeding?
Or the authority?
Correct.
Yeah, confirmed.
Thank you. That's all the questions I have.
Thank you. Okay, so we'll transition to cross-examination by the OCC and we'll go for maybe 45 minutes.
Good afternoon, Tom Wheel for the Office of Consumer Counsel. I'm going to start off with I always have a lot of confidence that I can multitask and get all this stuff together. I'd be better just waiting to talk until I'm ready. I'm going to start off with some follow-up questions from today. Mr. Hurwitz, I think you were responding to some questions from Mr. Bakari this morning regarding, I think there was a question to the effect of what reconciling mechanisms are accounted for in the rate year, and the question was specific to the CAM or to conservation expense. Do you recall that exchange?
I do.
I had a follow-up question about that. So I understood the testimony that the conservation expense is listed on both sides of the balance sheet, as it were, in the revenue requirement, so that it's both a revenue and expense, so it has no rate year impact, correct?
I think you said both sides of the balance sheet, and this would be an income statement item, but otherwise, yes.
Thank you. So, that is a reconciling expense though, correct? There's a conservation adjustment mechanism?
Correct. There's a separate rate mechanism for those costs.
Okay. So what does that mechanism reconcile to?
I don't understand. What does that mechanism reconcile to?
Yeah, so in that separate mechanism, it reconciles to actual costs?
Yeah, generally, it separate mechanism is intended to reflect the company's actual costs.
Okay. So, but there is no revenue in rates to cover that, to cover the conservation expense?
The conservation rate is capped by statute at a rate I can't recall. But that's the mechanism by which the company recovers these costs.
Okay. And you had responded in response to that question about reconciling mechanisms. I think you had you listed the COVID deferral, the GIS deferral, and the PGA. Well, those two deferrals, those would, just to follow your logic, those reconcile once, right? Like the idea is that those aren't built into, well, I guess I'll let you answer. How do you see those as reconciling?
I don't recall exactly the question that I was asked, but my recollection is I brought those up in response to a question that was along the lines of what's changed. And I mentioned a couple of deferrals that would not have been present last time.
Okay.
And I'd be happy to describe my understanding of those items more specifically if that would be helpful.
Sure. If you want to, the COVID deferral, what's the proposal for the recovery of that?
As in amortization period or?
Sure.
One moment. We proposed a 3-year amortization period for the COVID deferral.
Okay. And the rate, the way that would work rate wise would be that there'd be an element of rates for 3 years to cover that expense. And then after that was fully recovered, there'd be a rate adjustment downward.
Well, to, I guess, your question, we weren't proposing a separate rate mechanism for any of these regulatory deferrals. Rather, we were proposing to reflect in the revenue requirement an annual amortization for each of these items.
Okay. And isn't the company also proposing, and maybe this would be better asked of the capital investment panel, but isn't the company also proposing a mechanism to reconcile to actual for plant expense?
Yes, we are.
Okay. So that would be questions about that be better posed to the capital investment panel?
I think they would.
Okay. I have some follow-up regarding the colloquy today. It might have also been with Mr. Bakari regarding the earnings sharing mechanism related to RRU 667. And actually, I think Attorney Keenan might have just asked some questions about that as well. I just wanted to make sure I understood that well, there was a motion ruling from the authority in docket 180516, correct?
There was.
Okay, and I actually just pulled that up. Could it be that was actually motion 39? I think you testified at 38 earlier.
I would believe that.
Okay.
I have 38 in my notes, but I could have had that off one.
It looked like 38 wasn't there's a motion number 39, which is specific to the ESM, and looks like that's where that order is.
I believe you.
Thank you. So that, as a result of that order, the testimony I heard earlier, just making sure I understand, the company proposed to credit that ESM back to customers over a 3-month period starting in October. And as a result of that order, the credit was shifted forward in time to December through February. But was there no adjustment to the actual volumetric rate of the credit? And that's what caused the reason for the shortfall now?
That's exactly right.
Okay. Thank you. There was some testimony this morning related to RIU 449 attachment 1, the reallocation of technical shared services. I think Ms. Van Luling, this might have been your testimony. There was a testimony about, sounded like there was an error where the allocations were reversed between CNG and SCG.
Yeah, in the actuals, so in the financial statements, but we fixed it for the test year and what's in this filing.
Okay. Do you know, so one company presumably in the financials was allocated too much and the other was allocated too little?
Yeah,
Do you know
exactly.
which way which was which company? I guess I'll finish my question.
We have it in a data response. 1 second.
Okay.
It's CNG got too much, but it's further described in EOE 329.
Okay. Thank you. And this affected the test year 2022, correct?
Correct.
So according to the financials submitted at that time, the overall expense for CNG was higher than it should have been?
Correct.
Was that, and I heard you say that that was corrected for the test year, would that have affected the ROE filing from that year when CNG over-earned?
It would have affected the,
So wouldn't that mean that
That year.
CNG theoretically over-earned by more than what was reported?
we'd have to take a look too on those allocations. Some of them might be what we call below the line, so not included in the earning sharing calculation.
Okay, could I ask for that is that something you could read in or would it be better?
I can definitely do a late file. It might take me a bit of time to pull out what portion was below the line. So I prefer a late file if you don't mind.
Sure. Could I ask for a late file, Madam Chair?
Up to 18.
Okay. So that would be maybe just a calculation of what the impact would have been, if any, on the quarterly ROE filing for end of year 2022 for
Sure.
CNG.
Matt, do you want it both ways, CNG and SCG, or do we need to wait? Okay.
Both ways would be, yeah. I mean, and to that point, it would affect both, right? So
Yeah.
I'm sorry, both ways, meaning,
the impact of the misallocation of technical shared services expense between CNG and SCG on the quarterly ROE findings for year end 2022 for both CNG and SCG.
Okay, I'm gonna issue that to CNG. For now, we will cover extension of late file exhibits to SCG in the next panel, but otherwise noting that as late file exhibit 18.
Thank you. And I know there's also a late file exhibit on the next topic. I think it's late file exhibit 14 that's was requested regarding the derivation of the corporate capital charge, the 5.8 million.
Yep.
I believe the question was whether that was derived from the cost of capital from that rate case. I had a sort of a follow-up, more kind of theoretical question, which I don't think requires the late file. And I have some more questions about this in a minute that are similar to Mr. Pfaff's questioning about this, but following up on the company's testimony that there's the impact of the removal of the corporate capital charge is revenue neutral. If CNG's cost of capital is adjusted as a result of this rate case, would that have affected the corporate capital charge moving forward? Or was that corporate capital charge locked to that cost of capital at the time?
The cost of capital was adjusted based on the outcomes of rate proceedings, including primarily those of the authority. However, the concept of the phase out of the corporate capital charge being revenue neutral wouldn't go away. You know, the amount of the corporate capital charge would change as the cost of capital would change, but so too would the revenue requirement on the assets at the CNG and SCG level.
Okay. So at the risk of tempting Attorney Venora to object for asking a hypothetical, this is purely for understanding. Had there been no change to the corporate capital charge and there were a change to the cost of capital in this proceeding, that would flow through to change the way the corporate capital charge would be calculated?
It would have.
Okay, thank you. One other follow-up question on, I think the first questions I was asking about the crediting back of the ESM, the over earnings, pursuant to that motion in 1805-16. Have the over earnings from 2022 been credited back to customers for CNG?
One moment.
Mr. Wheel, we described that in our rebuttal testimony. Where we said, due to the difference between projected and actual billing determinants at CNG related to the refund of 2022 earnings sharing, CNG has a regulatory liability, including carrying charges as of the beginning of the rate year. So the answer directly to your question is yes. And consistent with the treatment of the over refund, the company has a regulatory liability for that year.
Okay. So, does that mean sort of that the company is seeing the regulatory asset that resulted from the over refund from the prior year kind of netting against the regulatory liability of the over earnings from 2022 and bringing those forward as a deferred accounting to be as part of the rate year in this case?
Right. We've proposed to treat them similarly in this case.
Okay. Thank you. Just gonna ask some of the questions I was going to ask the first panel. So just bear with me because I don't want to re-ask the questions I did ask the first panel. Well, I guess I was trying to ask the first panel just as sort of a level setting place to start to some questions about the concept of the earnings sharing mechanism and over earning in general. So I guess I'll start there. Would this panel agree that the return on equity is what we're talking about when we're talking about earnings in rate making context?
I think it's important to be precise, and earnings certainly could be used to refer to return on equity. Yeah, I think return on equity is just what it sounds like. It's the return on the equity that the company is invested in the provision of service to customers.
Okay. So right now, CNG's authorized return on equity is 9.3%, correct?
That is consistent with my understanding.
Okay. And what that means, well, when we talk about the return, that authorized return on equity, that's the percentage that's built into rates of the at the average rate base at the time of the last rate plan. Meaning the idea is that what's currently in your revenue is 9.3% of the equity portion of the average rate base in effect for the last rate year.
That's correct.
Okay. In other words, it's a fixed number that's in revenues when we talk about the authorized rate of return. But to your point, perhaps, well, I'm not sure what's your point, but in reality, as time goes by, because the equity proportion of rate base changes, that fixed amount, that fixed cost to the company isn't static like it is in revenues. Is that correct?
I think I can agree. Let me just state back to you, and I think this is what you said, but just to make sure. There is a static return on equity reflected in the company's established revenue requirement that has not changed since the final rate year of the rate plan established in the company's previous rate case, docket number 180516. As you indicated, the company's actual return on equity is not that. It's something that differs for a great many reasons. And the overriding one is that the company is entitled to rates that provide it an opportunity, but not a guarantee to earn its authorized return on equity.
Okay. Thanks. So at the end of every quarter, but for 2022, it gets complicated because there are these quarterly reports that have a 12-month look back. So we'll just focus on one. For 2022, the fourth quarter report in which CNG was over earning, essentially, is it fair to say that what the company did is it accounted for all of its expenses, all of its costs, its operational costs for that year, and looked at how much was left over, including the cost of debt. So with the only kind of cost that's not accounted for in that process being the return on equity, and used that number to determine what the percentage of that total sum was as compared to the equity proportion of rate base at that time. I guess I'm just trying to get explanation for what are we, when we talk about that 11.1, I believe it was reported on that 11.07, what does that mean?
I just want to make sure the witness panel understands the question because I heard several questions in there and I think it changed as you spoke.
Sure.
Attorney Wheel.
I did ask.
If you can kind of maybe restate a more direct question, please.
Sure. I think I answered the question that I then asked. So the question was, when the company reported that it had earned an 11.0% return on equity, what does that mean?
So maybe I'll pull up the calculation to which you referred the policy panel and maybe talk through it at a high level. I'm pulling up OCC 687 SCG attachment 1. And you are looking for information regarding calendar year 2022, I think.
Yes.
I said 687, but I think I meant
It's
691.
It's 691 and it's page 106 of that attachment.
Thank you. That is helpful. And in that attachment, I'll actually start at page 104. I know it's page 106 that contains the percentage, but page 104 is the beginning of our calculation. And this shows something that is similar to, but not exactly identical to what you were describing. You said you'd start with the bucket of revenue and then you carve out all of the company's costs. And I think the first point of clarification is no, we don't pull out all of the company's costs. Rather, There are certain amounts that are recorded below the line, which are not reflected here. We also synchronize interest expense to reflect the company's actual rate base. But this page 104 of OCC 691 CNG attachment 1 provides at a high level that step of the calculation. How much revenue did we take in? How much money went out the door for our operating expenses, purchased gas expenses, O&M expenses, et cetera. Then we turn next to computing rate base, because as I said, a return on equity is just what it sounds like. It's a return on the equity the company has invested. And as you mentioned, you one of your questions there acknowledged that it's equity invested in rate base. So to answer the question, what is the company's return on equity? You have to know what the company's rate base is. Page 105 summarizes our computation of that rate base. It includes plant and service, working capital, materials and supplies, the other items shown here. And then page 106 is the math that takes the outputs of those previous two pages, utility operating income and rate base, combines them with our capital structure and various costs of capital for non-common equity sources of capital, and formulaically produces the company's earned return on equity for this trailing 12-month period.
Thank you. That was better than when I attempted to testify via a question. Going back to page 104 of that exhibit where you started, there's a line item there for total operating income. What is operating income?
Operating revenue less operating expenses.
Okay, and it looks like
It's defined by a gap.
Okay.
So it's following the gap defined income statement.
Okay. Thank you. And going back to the questioning I just had a minute ago, when we talked about that there's a static return on equity built into rates and that the rate doesn't change. The rate model that was allowed by PURA also includes a line item for operating income. Is that correct?
I'm just pulling up the settlement agreement that resulted from, that was approved in 1805-16. One moment.
That operating income is a bit different than this operating income because of the way that taxes were treated. So it looks like this is what's in 1805-16 is not in the US GAAP format because they're taking operating revenues less operating expenses, then tax affecting it to get to an operating income number. And when you're looking at page 104, the operating income is just operating revenues minus operating expenses. So it's not tax effect.
Okay, so that's the income prior to having to pay tax?
Prior to the income tax expense line item, and as well as on 104, it's also prior to other income and other deductions, as well as prior to interest charges.
Okay. How come I see income taxes above that line item on page 104?
You're right. 1 second. I stand misspoken. You're right. The income tax line item is included above in operating expenses.
Okay. So, so the operating income that's built into rates is structured the same as the operating income that's listed on the.
Yes, it appears so.
Okay. So the operating income that's built into the current rate plan for rate year 2021 is $39,127,000. Is that correct?
Correct.
Okay. And then in 2022, when the company over-earned, perhaps unsurprisingly, the operating income was higher at $43,973,000.
That is correct.
Okay, thank you.
So one other item to note, there's the DIMP program and the SIR program were also in effect that would not have been included in the revenue requirement coming out of that last rate case. And so as your rate base grows, you're getting, for those programs, you're getting operating income associated with those, which is another driver of why that would be an increase, but not necessarily an increase in your ROE. Because when you go to do the ROE, you have a higher rate base than what you would have had in the rate case.
Okay. So I noticed the 2023 annual filing is also in the record. It's in that same OCC 691 attachment 1, but it's on page 125. And I noticed the operating income for that year was also higher than that amount allowed in the rate plan. Is the reason for that what you just described?
Yes, because one moment. That's exactly it. And you can see that the ROE on page 127 of 2023 is 8.21%. So we've grown those rate base amounts higher than we've been able to grow the revenue. So even though net income is higher, the ROE is not higher.
Understood. I guess I'm just confused, and maybe this was a better question for the first panel, but perhaps you can ask. It just confuses me as sort of a non-accountant. If your operating income is still higher than what's allowed in base rates, then why there's a perceived revenue deficiency necessitating a rate case?
And I think it goes back to what I began with, that it's the return on how much equity you invested. We've invested more equity. An ROE is not just a dollar figure. It's the percentage. It's earnings divided by amount invested to attract those earnings. And the amount we've invested has grown. In fact, you can see on page 126 of OCC 691, CNG's average rate base for calendar year 2023 was $591.8 million, whereas the settlement agreement established reflected an average rate base of almost $60 million less, $534 million.
Yeah, thanks. I did understand that. I guess a better way to phrase the question is we were just talking about sort of what's above the line on the operating income reports. And it seems to me that everything other than the cost of debt and the cost of equity essentially is above that line. So what this doesn't this year-end 2023 report show that the company had more operating income than it needed to cover its costs?
No, that's not what it shows. Again, this shows the company earning less than its authorized ROE because of rate-based growth. And I also don't know that I agree that basically everything has been included in the computation. I see other income and deductions, which is not picked up in utility operating income. I see other interest charges, which is not picked up in other interest charges. So there are line items of the income statement that are truly below the line for purposes of this calculation.
Yeah, I understand that too, but there are also, there are O&M expenses listed here at $45.849 million. And the company had revenues via rates designed to derive an operating income of $39 million, like we talked about before. And at the end of calculating for those O&M expenses, the company was still collecting more, still had more operating income left than what was designed in rates. So I'm just not sure how, for instance, O&M necessitates an increase when the data seems to suggest that there's more than enough revenue to cover it.
And maybe I'll try a simple example, and I'll offer you a theoretical investment that pays $100 a year in return. If you have to invest just $10 to earn that $100, this is a fabulous investment. $10 to earn 100, who wouldn't do that? If you invest $1 billion to earn that 100, it's one of the worst investments ever. it is not economic to invest. And so I think the point we're trying to make is you can't analyze operating income in dollars in isolation. Rather, you have to know how much money was invested to earn that operating income. And the point we're highlighting is that rate base has grown very significantly and will continue to grow very significantly by the tune of tens of millions, if not hundreds of millions of dollars.
Yeah, thank you. I do understand that. I don't mean to be ignoring you, but a component of this rate case is seeking an increase in depreciation expense and return on equity to account for that increase in rate base, correct? But then there's also tons of other components in this rate case, and that's those components that I'm curious about.
And we would agree that those other elements of the company's operation are an important part of determining the revenue requirement, which is why we've proposed a revenue requirement that reflects the company's operations as a whole. It's why we've requested a revenue requirement that reflects the cost the company must incur to safely and reliably operate the business.
Okay. Thank you. Looking at page 14 of the initial revenue requirements testimony, there's a table showing rate year rate base. Showing the 13-month average for CNG as 594,664,000.
My apologies, you've gone a little too quickly for me.
Sure.
Which page of our direct testimony?
Page 14. I should also open it to make sure I'm not. Sometimes when I read from my notes, I'm totally wrong. Just a second.
Page 14 of the PDF, or?
I believe I'm referencing the labeled page on the testimony itself.
Right, Attorney Wheel, it's page 14 of 62. So it's the document page number.
Thank you. Yep, and that's PDF page 17.
We're there, thank you.
So that's let's see what was the point I was getting at. So that the number around just under the table 2 at line 10 shows that's the proposed rate year 13-month average rate base of 594,664,000 for CNG, correct?
Correct.
Has the company calculated that average rate base for the last financial filing I've seen was recently filed, the year-end 2023. So what, I guess a better way to ask is, what's rate base right now?
As of December 31, 2023, average rate base was 591,820,000, or just less than 3 million less than the rate base we're seeking in this proceeding.
Okay.
That value is provided on OCC 691 CNG attachment 1, page 126.
Okay. Thank you. And I'm looking at Schedule B1. The test year ending rate base balance there is 607,642,000.
I see that.
So what is driving the reduction in rate base between the beginning of the test year and now, or most recent number?
The primary factor is gas inventories. I'm looking at B1.0 also, and I'm fixating on both Excel row and labeled row 22, labeled materials, supplies, and gas inventories, which goes from 59.6 million as of the end of the historical test year to a rate year average value of 29.2 million. That decrease is driven by many things, but 2 primary factors. One is for the test year, we've reported the test year ending balance and gas inventories demonstrate a high degree of seasonality. And so by going from a test year end to a rate year average, there's a material decrease there. And then second is the cost of gas was quite high in the test year. causing the value of gas inventories to be higher, all else equal. There are a variety of other factors affecting our rate base, obviously, but that's, I think, the largest answer to your question.
Okay. And you can actually maybe see the seasonality impact by comparing the column labeled rate year 2024 ending balance, right? Which is 40 million. So that maybe that takes care of the seasonality comparison to compare that 40.5 million against the 59.6 million test year ending balance.
That does illustrate the seasonality relatively nicely.
Okay. So it's about a $19 million delta that's attributable to the pricing.
Oh, I see. One moment. It's in that range. The source I would have gone to get an indication of that is OCC 691 CNG attachment 1, page 105, which is the rate base summary we were just looking at a moment ago. That page provides rate base both as of the end of the period and the average period over the period. And I was comparing on that page numbered lines 3 and 13, which differ by approximately 16 million. But I think there's some test year, rate year differences in there. But if you're just looking for an indication of the degree to which seasonality affects these numbers, that's where I would have looked.
Okay, thank you. My next question was going to be about the difference between the rate year starting balance of 587 and the rate year ending balance of 654. But is the seasonality factor a component in that? So I'll back up a little. That's about a $67 million increase in rate base over the rate year, correct?
Yes, I found 67.177 million in difference.
Okay. And is the seasonality that you just described a factor in that increase?
Seasonality is a factor. However, in this instance, I don't think it's the largest one. Here, I think the largest factor will be twofold. Number one, the continued plant additions that we will be making as a regulated gas utility. Our business is capital intensive, and we've invested tens of millions of dollars into our system every single year for the past several decades, and we anticipate continuing to do so in the future. The rate year ending balance will reflect one additional year of plant investments that the rate year beginning balance will not. Conversely, our assets will continue depreciating over the course of the rate year, causing a partially offsetting growth and accumulated depreciation. Those are going to be the two largest factors for the difference between the rate year beginning and ending balance, much more so than seasonality, because the beginning and the end of the rate year both occur at the same time in the year.
Ah, yeah. Okay. And you can see that there's a gross plant growth of about 100 million, looks like, from 1.316 to 1.413, but then net, which maybe reflects the depreciation you were just mentioning, is more like a $60 million increase in plant. Okay.
On that in round numbers,
yes,
those obviously we could do the precise calculations, but
yeah. And for the record, I'm still referring to Schedule B10, and I'm rounding with my questions. Thanks. Looking at page 15 of your initial testimony, table 3, which we might not need to reference because I'm just using it as a touch point to ask, the proposed capital structure in this rate case is comprised of 55% equity?
For CNG, that's correct.
CNG. And looking again at that last quarter 2023 financial filing, it looked like the last reported actual equity component was 60.16%. Is that accurate?
1 second. 60.16. Yes, I see that.
Okay. So what's driving the difference between those numbers, the requested capital structure and the actual capital structure as of most recent reports.
One moment. Mr. Wheel, we think questions regarding how the company chooses to capitalize itself might be better answered by our cost of capital panel.
Okay. Sure. And maybe this next question might make more sense for them as well, but is the plan with the requested 55% equity component, does the company expect its actual equity financing to trend downward towards that in the rate year?
I think that would also be best addressed by the cost of capital panel.
Okay. Maybe this also might be better for the cost of capital panel, but is there a difference between the actual capital structure and a capital structure that's used for rate making purposes?
Yes, there can be.
Okay. In your experience, is it common for the actual capital structure to differ from the authorized capital structure for a given rate model?
I've seen that happen, yes.
Okay. We were speaking a moment ago about the plan to increase plant and service over the rate year. But that, just to qualify, so that was, we were just talking about the rate year, but your testimony on page 17, line 3, talks about plant expecting to increase by $305.5 million over the balance currently in rates.
I see that.
So that's the distinction between the level of plant that was built into rates in the last settlement for the 2021 rate year versus are you comparing that to the average balance in the rate year?
For the specific calculation of these numbers, whether it was average or end of period, I'd have to check our records, but conceptually it is just that is the rate plan currently in effect for CNG reflected some level of rate base for 2021 that's different from what the company's actual rate base is today.
Okay. So yeah, I mean, so maybe subject to check, the 2021 rate year authorized level of plant was 1.06 billion, and the company's proposed average, that was I might have not have specified, that was the authorized average plant balance was 1.086, and the proposed rate year average balance is 1.351. So I did that's math I can do, and that's 305.5. So is that where you?
Yeah, that sounds correct.
Okay.
That sounds correct, excuse me.
Okay. So if I compared the 2021 rate year beginning plant balance, I was trying to figure out how to determine that, and I don't know, I don't have it, but what I do have is the end of period plant for 2020. Is that it? Would there be a difference between those numbers, the end of period plant for 2020 and the beginning plant balance for 2021?
Where did you get the end of period 2020 balance from?
From the, one moment. That's also, and I just have to scroll all the way up to get the reference.
Oh, from OCC 691?
Yes.
No, those will not necessarily be the same. OCC 691 would have reflected our actual results over time. Whereas the settlement agreement in CNG's most recent rate case would have been established in the 2018 time period looking forward. So that beginning of rate year 3 value, well, you would expect, the end of rate year 2 to be the beginning of rate year 3. Since you're pulling them from two different sources, they may not necessarily align.
Thank you. That makes sense.
All right, let me know when you're at a stopping point, please. sir.
Anywhere works.
Okay, well then, we're stopping.
Okay.
All right, thank you. So we'll resume in the morning at 10 a.m. We'll continue cross for the OCC, please.
Thank you.